The writ petition being devoid of merit stands dismissed, interim order stands vacated.
Supplementary list, 4 left out, Lordship. One order will cover all the matters, Lordship.
If you can bring it before you rise, we can have, otherwise not.
Lordship, we will try.
You try. You should have mentioned yesterday. What prevented you from mentioning?
In supplementary list, some matters.
We are not aware of this. We have been allowing all motions, as you know,
Yes.
all, everything, whole entire week. Don't burden us in the last date. If you bring it before rising, no, it's not like that. It's not like that. It's not so easy for you. For you, it's easy.
Lordship.
We have to go through the
Try.
records.
We will
You
try.
will try to bring it, we'll see.
Sure.
Yes. Only the motion matters.
Article 16 for withdrawal.
Matter has become infructuous because subsequently election held, madam.
Okay.
So,
Heard Sri P. Sinha, learned counsel for the
petitioner.
petitioner. Also heard, Madam, you have a cooperation. Name?
A Das on behalf of SK Talukdar, sir.
Also heard Miss A. Das, learned counsel appearing on behalf of Sri S.K. Talukdar, Standing Counsel Cooperation Department. Full stop, Sri N. Das, learned state counsel is also present, para. Sri Sinha, the learned counsel for the petitioner, has submitted that due to subsequent developments, there is no requirement to press this writ petition. Full stop. The writ petition accordingly stands dismissed on withdrawal.
Item 1.
Yes, madam.
So this matter regarding enhancement of the value of land of the petitioner lordship. Their land was remarked on in the year 2016, but acquired by the Kala lordship 2023. After that,
Lord, this alternative remedy is there because enhancement of compensation. But that apart, that we have already paid in 2016 itself. If it is on 21 separate, then also, anyhow, this matter will be decided by arbitrator under provision of section 3G5.
But your grievance relates back to 2018.
she submitted two representation
not
for
so.
the Kala only.
When?
One is 2023, another is 2025 lordship.
Now, what about from 16 to 23?
Immediately it would have
That
been.
time-
Even if we assume that the representations are correctly done,
They have no idea about, but the land is acquired on 2023, which just.
no idea about what? No idea about?
Lordship, at this time, we just want to
Oh,
consider
at that time, you did not have any idea about what?
that time, that time the land was not acquired by the Kala lordship. 2023 acquired.
Kala does not acquire land. Does Kala acquire land?
Competent authority, Kala lordship in this matter.
Does it acquire land? Kala does not acquire.
National highway. National highway.
National Highway lordship. Similar matter lordship, the representation consider already.
16, how do you entertain this? And you have alternative remedy. What is your answer to that? What is the answer to that? Let us see your representation. Page
Page 143 lordship. The
140
last representation and another is 140.
143,
139 is first representation, that is 2023.
139.
Lordship. And second representation, 143 lordship, and actual 4 lordship.
Lordship 143, it clearly says they have already filed application before the learned arbitrator under section 3G5. That means it's pending before that.
It's not
That's 143 in phase lordship periods.
Okay.
Just-
Ms. E. Begum, learned counsel for the petitioners who are aggrieved by the sufficiency of compensation for acquisition of land. Full stop. Para. Sri C. Barua,
For my lord,
learned standing counsel, NHIDCL,
my lord, my lord.
has however submitted that the acquisition was of the year 2016. And apart from the delay in approaching this court, comma, there are remedies available in the act itself. Para. Be that as it may, let notice be issued, returnable on for 2nd of February 2026. Yes, who's taking
Secretary.
notice? Ms. G. Hazarika, Learned Standing Council Revenue for 1 and 2. District Commissioner
3, 4, 6, my lord.
3, 4, and 6.
I am for 5 minutes.
And thus State Council, and 5 is NHIDC, C Board of Standing Council. Extra copies. The issue regarding maintainability of the writ petition
No.
is however
not
kept
that.
open.
This copy.
Is however kept open.
Lord,
Maintainability is open.
extra copy already served.
How it's a data's original copy doesn't know.
Chief,
Hard copy.
Madam, these are matters for dispute again amongst yourselves. Don't be kind of put this kind of disputes in the court. We are not deciding whether extra copy serve or not.
times already served. That's why I am saying that, Lordship. Much obliged.
Extra copies to deliver.
I didn't do.
Yes, Mr. Roman?
Director Lordship, my lord. On the last occasion, on 7/11/2025, the coroner.
What is your grievance?
Grievance is, my lord, I invested in dollars, my lord. And I was defrauded by the staff, my lord, of the ICICI Christian Boston branch, my lord, and that was, complaint was made before the cyber crime cell. And for the last 3 years and 3 months, no investigation was done. I also do not know what investigation has been made.
Is
And
there, is
subsequent-
the ICICI having any standing counsel? Mr.
Lordship.
M. Sharma appeared, M. Sharma.
I can.
No, we can.
Lordship, we have been directed to file an affidavit.
Affidavit has
from
been
our-
filed, my lord.
We have filed our affidavit, whether it's there in the. court
Yes,
file.
affidavit is there, by response number
Affidavit
3.
is filed.
From the affidavit, it reflects that there is, after investigation, nothing wrong was found.
My lord,
Oh, let us issue notice. Let ICICI also respond to this.
Lordship.
Heard. 3. S.S.A. Rahman, Learned Counsel
Unoish.
for the petitioner who is aggrieved by the inaction by the respondent authorities to look into the complaint whereby the petitioner has alleged fraudulent practice so far as his bank account in the respondent number 4 bank is concerned. Full stop. Para, pursuant to earlier orders of this court, comma, the respondent number 3, that is the senior superintendent of police, Kamrup, has filed an affidavit as per which no malpractice has been detected
no.
after the investigation. Para, be that as it may, let notice be issued, returnable by returnable on 2nd of February 2026 to 2, huh? Mr. Sharma for 1, 2, 3.
1, 2, and 3.
1, 2, and 3. 1, 2, and 3. 4, 5, 6, 7 by speed post to ADs. Steps within 2 working days.
My lord,
The petitioner is at liberty to file rejoinder affidavit
my lord, my
to
lord.
the affidavit in opposition of the respondent.
Highly obliged, my lord.
Second. Yes, madam.
Lordship, all the petitioners are legal heirs, my lord.
Legal heirs of whom?
Legal heirs of this, my lord. One of this, my lord, Anandamoy Chakravarti, my lord. My representation is, my lord, annexure for page 61.
What do you want? What do you want?
My lord, the issuance of patta, my lord.
Issuance of patta?
My lord.
No, they are, they are apprehending eviction. apprehending eviction, in spite of there being an order passed by this honorable court at page 88.
That order was, my lord, earlier. another-
88, the relevant portion is at page 89. Has your lordship got it? Page 89.
89 is very clear.
Yes, 15
Even
days.
if you want to evict, you have to follow the process.
Yes,
My
How
lord,
can you
I
have
am
another
sorry,
order?
my lord, and the representation also submitted, my lord.
Now, what is
representation-
your prayer now? Let us see your
My lord,
prayer.
My lord, issuance of patta, my lord.
Let us see. Page.
Representation is page 61.
No,
my lord.
no, your
the
prayer.
prayer 24, page number 24.
You are the legal heirs of a Khatian holder. Now your application has been made under which act? Under what provisions of law patta will be granted to you?
19/124, my lord.
No, under what provision of law, which law pattas are to be granted to you, to the legal heirs of a Khatian holder?
My lord, page 61, there are 4, my lord.
Page 61.
My lord.
Please read.
My lord, there are 4, my lord, for conferment of landholder status to a person holding this land under government. Any persons also on the commencement of this act and holding any land directly under this government in area under any of these provisions of Assam State Acquisitions of Jamidari Act 1961 shall continue to hold the same under this regulation with the status of landholders and subject to payment of such land revenue as may be assessed as per the provision under these regulations, my lord. And petitioner.
So where is the provision for grant of patta? These are provisions that you'll remain as a tenant. How do you trace your present claim with some rights vested to you by some statute? See, your claim has to be based on certain rights which has been vested upon you. You show us under which statute the right has been vested.
My lord, at this stage, notice may be issued and I.
First, notice is not as a matter of routine, madam.
My
You
lord,
have to
I-
prima facie make out a
additional
case.
my lord.
Yes?
Additional affidavit also filed, my lord, with provision.
So as the provision. For that
Yes, madam.
affidavit is not required. Just show us the law, the statute.
After vacation, my lord, any day.
This is not done. You're wasting the time. There are many other advocates with their cases, respective cases. In this writ petition, a prayer has been made for allotment of patta to the petitioners who claim themselves to be the legal heirs and successor of the original Jodhar and tenants in respect of land under Khatian, under various Khatian numbers in the Bilasipara town, full stop. The learned counsel is however unable to show the provisions of law under which such a claim can be made. Paras. Ms. Wazida, the learned counsel, at least is praised for some time to obtain necessary instructions. Paras. List for motion on 9th of January 2026. Come prepared, madam. Yes, Mr. Deka.
Today is the fixed for instruction. Malam, I need some more time, Malam. Instructions are yet to be received, Malam. Huh? No. Don't know what's the file.
You presently it's annual patta.
Yes, but already you have, since 1992, yes, Malam.
You want conversion into Miadi patta.
Yes, Malam.
Have applied for it.
All
Will
noted.
issue notice at this stage. Third, Sri P.K. Deka, learned counsel for the petitioner who is aggrieved by non-conversion of 2 plots of land to Miadi patta. Full stop. It has been contended that
Notice is.
applications for such conversion do made are pending consideration. Put the para. Plat notice be issued returnable on 21st of January 2026. Madam Hazarika, for one only.
One.
And 2, 3, 4, and thus extra copies.
My lord, annexure 12, page 43, my lord, there are one representation made, I made. before this-
Pendency of this
Yes,
writ petition shall not be a bar for consideration and disposal of the representation said to have been filed in accordance with law.
Deeply obvious, deeply extra purpose, indeed.
Yes,
Lordship, I'm,
Instruction was short.
yes, Lordship, I am praying for some more time, Lordship. We have not received any instruction.
what is the allegation in the FIR?
Actually, a particular society was allotted the work lordship. Now, some miscreants or if we call rival group was obstructing him from doing the allotted work lordship.
For that,
Subsequently, FIR was registered, but thereafter police was.
let us issue a short notice.
Lordship.
Or you, okay, we'll do one thing. We'll have it for motion immediately after the vacation. You in the meantime.
Lordship.
Though instructions were directed to be obtained via order dated 24/11/2025, comma, through H. Sharma, Learned Council, State Council has paid for further time. Full stop. Para, we'll issue notice pending since long. The petition has been filed alleging inaction on two FIRs lodged on 16/9/2025 and 20/11/2025. Full stop. But the law on the subject is very clear that in matters of non-registration of FIR, oblique inaction, oblique improper action, comma, the role of the writ court is a circumscribed one. Para. Be that as it may, comma, since a direction was granted to obtain the instructions, comma, let the instructions be obtained and the matter be listed for motion on 9th of January 2026.
Of the lordship.
Yes, Madam Thakuri.
My lord, in the last Panchayat election, my lord, the petitioner was also a candidate in Thanwa Gaon Panchayat, my lord, 10-14 Thanwa Gaon Panchayat, South Salmara, my lord. And the respondent number 5 was also the candidate and she won the election, my lord, by furnishing some false, my lord, information, my lord, documents, my lord. At the time of
False document regarding what?
my lord, regarding her
Education.
age of marriage. At the time of marriage, she was minor, my lord.
Okay.
That is the case, my lord.
Okay.
And he has already submitted some complaints before the district commissioner, my lord, but no step has been taken, my lord.
Okay, yes, what do you say?
At this stage, notice me, woman.
No, what about the aspect of grievance redressal? How is it done?
My lord,
Deputy Commissioner is power.
District Commissioner is.
Yes, my lord.
Yes.
Deputy Commissioner.
This room tomorrow.
Section 127.
127 to Beleg.
তাতে সেইটো নহয়, আছে।
What about 129?
My lord, this is Gao Panchayat, my lord.
That 11 is only for president and vice president.
Yes, yes.
It is for the election of a ward member.
62 is, rule 62 is there, my lord.
Rule 62.
For section 111.
Yes.
For some criteria, my lord.
Now, 111 lays down the aspects of qualification. How will be disqualified? Then
Yes.
how do you adjudicate? Where do you,
Rule 62,
what does it say?
my lord.
Mm. 62,
It's a conditions and procedures of disqualification.
6.
Rule.
আমরা ruler, itu sorry.
Rule 4, yes.
It-
Rule 4, my lord, is saying, my lord, subject to the provisions of the Act, at the time of filing nominations, the candidates shall furnish affidavit regarding their age at the time.
Mr. Dutta, that is not the question we're asking.
Yes,
That is the allegation. Where is the dispute redressal mechanism?
My lord, my lord.
This is not 129.
My lord, B, my lord. 4B,
Yes.
the state government or concerned district authority shall remove any president, vice president, or member of Zilla Parishad, Anshalik Parishad, and Gaon Panchayat if it's found that her or his or her spouse was underage at the time of marriage.
Who will decide?
My lord, district commissioner can
Where?
decide, my lord.
From where?
From my lord, 462 rule 62 4B,
Who
my
is the
lord.
power of removal? Who will decide? Where is the dispute redressal mechanism?
In that case, my lord,
There is a tribunal, my lord, regarding election tribunal.
Yes.
There 127.
129B.
127.
129B is the bar, my lord, and 127 is the district jurisdiction of the tribunal, my lord.
That is what we are trying to extract
Yes,
all this
yes.
time.
Yes, yes, my lord.
So if there is a tribunal
My lord,
which can decide this kind of dispute,
my lord,
where
Decide.
is the scope of a writ court?
my lord. Lordship is very much correct, my lord.
Madam,
There is no such court, my lord, when he asked.
no tribunal.
My lord, when he
Tribunal.
inquired in the election office, my lord, they asked him to submit his complaint before
No,
that.
it's not the election office. Tribunal is not the,
They informed him that to him.
so the district judge has been conferred the power of a tribunal.
Yes.
You have to approach the tribunal.
No, there is no such tribunal, my lord.
District judge. There is no district judge.
But
These are
they
question-
asked him to, my lord, to submit his
These are
complaint.
matters involving questions of fact. Even if we admit your or issue notice, tomorrow the questions of fact would come. How do you prove? You say that the private respondent is involved in child marriage. This is an allegation made by you.
Yes, ma'am.
The burden is upon you to prove that there was a child marriage. How do you prove in a writ court?
He has already.
If the matter that you have approached the tribunal, nothing has been done, then you come to the writ court. We give a direction to the tribunal to decide. Now, you have come directly to the writ court. We cannot decide.
But there is no such tribunal, my lord,
District judge.
district judge. But can you tell me what
Yes. Already notified, my lord.
And you have to raise an election dispute within that particular time.
That is also.
Yes, my lord. Election was held in the month of May, my lord. In
Yes.
the month of June, my lord, 9th of June, he filed his complaint, my lord,
Before whom?
by district magistrate.
District
District
Magis-
or district commissioner, my lord.
District Commissioner is not the adjudicating authority.
তাতে একো নাই, তাহাঁতে কৈছে দুটো ইলেকশ্যনৰ পিছত কৈছে ডিষ্ট্ৰিক্ট কমিশনাৰ তাত দিব দিছে। তিনিখন পেটিশ্যন দিছে।
Come to 129B. 129, we are hinting upon 129. B. Section. Please help your Mr. Datta.
My lord.
If you are having this book, it's page 137. Which book are you carrying? Yes.
137.
Read 129B.
143. 143. 143. Please pause.
Please read, madam.
Yes, madam. No election to any panchayat shall be called in question except by an election petition presented within 60 days from the date of declaration of the election results to the tribunal constituted under section 127.
And this you read it 127. 127 is with regard to constitution of a Panchayat election tribunal.
Right.
District judge has been vested with the powers. And there is in 127, you find there is also an exception of section 10 of the act, which is with regard to president and vice president of Gaon Panchayat. That will be decided by the district
District.
commissioner. So these are not pertaining to president and vice president. This pertains to election of a ward member. So it is only through a tribunal election petition which you can, but the problem is that 60 days are over. When was the election results? May?
May, yes.
We are in
June, my
December.
lord, he has filed
60
on-
days.
No, within period, my
No,
lord.
that is not before the tribunal. That is before the district magistrate or the district commissioner. There are no powers for condemnation. We do one thing, but there is a private respondent.
My lord.
Without issuing notice, that will be not proper. We'll issue notice, but not maintainable. And we cannot, without hearing him, we cannot make an observation for.
On his complaint, my lord, he was called, my lord, last annexure, my lord, page 56.
That is not, that
By
is
the
not,
Assistant Commissioner cum District Child Marriage Prohibition Officer, my lord.
see, those may be materials which can be taken into consideration by the adjudicating authority, report of the child marriage officer.
Yes.
But that is not the adjudicating authority. Adjudicating authority is only the tribunal.
My lord, may I suggest one thing? My lord, rule 62 4C is the
Hmm.
procedure, my lord,
Hmm.
by which, my lord, district commissioner can remove after facts finding, my lord. So at best, my lord, lordship can.
62?
62 4C is the procedure, my lord. At page 230, page number 230.
4C.
Yes, my lord. 230, page number 230.
Yes, yes.
Yes. This is the procedure, my lord. How district commissioner can remove under this provision. So lordship can dispose of this matter directing district commissioner.
No, but
Follow.
here the report has to go from the Gaon Panchayat secretary.
Yes.
President and vice president. Member.
Or member is there. Member also too.
All members.
Yes, sir.
Now it is for the duty is cast upon the secretary
Yes,
to inform the BDO and who will ultimately inform the.
he can approach secretary, my lord, then secretary will forward the information as per this rule, my lord. Otherwise, tribunal's time is already over, my lord.
Okay, heard. Miss N.S. Thakuria, learned counsel for the petitioner who is aggrieved by the election of the respondent number 5 as member of ward number 14/10 as from the ward number 14/10 Dhanwa Gaon Panchayat in the district of South Salmara Mankachar. Full stop. It is submitted that the said, what is the false document?
My lord, may I show?
Said furnish false documents
Regarding.
while submitting
Yes, my.
nomination and is involved in a child marriage. Correct?
Yes, my lord.
The petitioner claims to have approached the district commissioner, which such representation has not been considered. Where? S. Dutta, learned standing counsel, PNRD, has however submitted that the information regarding involvement in child marriage is to be given by the Gaon Panchayat secretary. Is to be given to the Gaon Panchayat secretary, who would take onward action. In this regard, he has referred to the provisions of Rule 62 within bracket
4C.
4 within bracket C of the Assam Panchayat within bracket Constitution bracket close Rules 1995. Let notice be issued returnable on 2nd of February 2026. Sri Datta, the Learned Standing Council PNRD, except for one,
1 and 3.
1 and 3, and thus for 2, Election Commissioner NB Caster for RW for 4, extra copies, 5 by speed post with AD, steps within 2 working days. Pendency shall not be a bar for the petitioner to file appropriate representation before the Secretary of the Gaon Panchayat in accordance with law.
Order to
Deeply obliged, my lord.
Obliged.
Mr. Montos?
May it please, Lordship. Basically, it is, I am a tenant, Lordship, that is landlord, when I have a restaurant called Missing Kitchen. If there is a dispute between landlord and me, Lordship, and which result, my water connection and what electricity maintenance had been stopped by this. Therefore, then the individual civil suit is pending. And therefore, Lordship, what happened, I filed an application before the GMC of the Municipal Authority Author, Managing Director.
Where is the APDCL?
APDCL, Lordship, I have no dispute with it. Connection has not been disconnected, Lordship, but it is for maintenance. My AC maintenance door has been closed. The connection has been not tested. The connection is getting there.
Writ petition is against whom?
Against water connection, Lordship.
Water connection is.
Water connection.
What is the, how do you deal this kind of a problem? If there's a dispute between landlord and tenant, what is your role? How do you, there's a,
Only thing is that they want a water connection from the municipality, that is what you mean, Metropolitan Drinking Water and Sewage Board. And that this process is online, and they have in page number 45, they have given an offline application. They are agreed that.
why don't you apply online?
Lordship, online I can because tenant cannot. Lordship may, sorry, landlord may apply, Lordship. But there is a.
No, in this kind of situation, how do you address, how do you, suppose a tenant, can a tenant ask for a water connection?
Yes, because Article
If I
20.
submit, a civil suit is pending. Already there, he can file an application not to disrupt the water connection.
Application is your right.
And in this case, my lord, the honorable court will pass necessary order. And I think Assam Urban Rent Control Act, there is a
Yes, there is a
necessary.
necessary provision in clause
Which
6.
That
also
is one of the
might
essential
safeguard the
conditions.
interest of the tenant.
That is
This
one
is
of the
not
essential
dispute, Lordship.
condition.
That is the not problem, Lordship.
Then,
Water connection has been already stopped, Lordship. Water connection, because Lordship is kindly see page number 44 and 40.
that is one of the condition, Mr. Das is absolutely right. Under the Urban Areas Rent Control Act, this is one of your rights.
Yes,
Vested
Lordship.
rights of a tenant.
By this observation, if Lordship allow me, Lordship,
Yes.
and
Okay,
Lordship may
okay.
dispose. I
Fine.
will file, Lordship.
3, D. Mohanto, Learned Counsel for the petitioner. Also heard 3, S. Bora. Learned-
1 and 2.
No, I also heard 3, and thus Learned State Council, as well as 3, S. Bora, Learned Standing Council. GMGA,
Not my lord, this is Guwahati Metropolitan Drinking Water and Sewage Board.
Guwahati Metropolitan Drinking Water and Sewerage Board, full stop. Though there is a private respondent, comma, in view of the order proposed to be passed, comma, issuance of notice may not be necessary, full stop. Para. The approach to this writ court has been done to enable the to have the water connection to the premises under the petitioner. Full stop. As per the facts projected, comma, the petitioner is a businessman and running a business of restaurant in the name and style Missing Kitchen. Am I SS or S? It will be single S.
It should be single S.
What your kitchen is missing? Where will you go? You
Yes,
cannot go to a missing kitchen if it is missing. You should write properly.
Lordship.
Your client will not be happy with you.
Lordship.
MIS, huh? Missing kitchen. And running a business in a tenanted premises of the respondent number 3, full stop. However, there is a landlord-tenant dispute which is presently before the
Before the civil court.
which court?
Lordship,
Civil Judge Senior Division number 1.
Before the civil judge senior division number 1, Kamrup M. Full stop.
196
The-
17.
one,
Petitioner is aggrieved by the refusal to give water connection as well as access to the air conditions outdoor units. Full stop, para. 3, Das, the learned,
Suit has been dismissed, appeal has been dismissed. Presently, CRP is pending.
no, Lordship, yes, this suit has been dismissed, but counterclaim which it is pending before in one.
counterclaim by whom?
Counterclaim by the defend respondent number 3.
What will you get there?
That will be for eviction only, madam.
And that will be
Ejectment
eviction,
only,
Lordship.
that is-
Eviction suit is.
When your suit has been dismissed, can you maintain an interlocutory
My
application?
suit is not for, my suit is for renewal the lease, Lordship.
Exactly.
That has been dismissed.
It has been dismissed and CRP is pending before this.
You have to file an application, get a
Before the
liberty in the revisional code, then
Yeah.
you have to file.
Yes, I've been revisional court, that's pending, Lordship. In,
So you have to get a liberty from the revisional court.
Yes.
Lordship, it is,
Revisional court's powers are very, very limited.
Lordship.
They will not direct electricity or water.
Lordship, there is a pending, civil revision is pending.
So you have to take a liberty from the revisional court to approach the civil court to file an application for orders. Your suit has been dismissed. In the dismissed suit, how do you approach the same court? Only on the guise that a counterclaim is pending. It is for adjudication of the counterclaim, not your claim.
Not my claim, but in this order, when suit is dismissed, there is a order that suit will be remain, Lordship. Counterclaim will be remain.
So counterclaim is not decide your rights,
Lordship, their rights,
their rights.
their rights.
That's why
But
we
in
have-
the.
Even if you assume that the counterclaim would be dismissed, then also you cannot get an order for electricity or water connection.
No, Lordship, in Matsur Paras High Court, Lordship decided that Lordship, because if there is a civil suit pending, there is no bar to give water connection, but what can, civil suit, what will decide?
Mr.
but ownership,
Mohanto, don't cite case laws out of the cuff.
Lordship,
Case laws have to be read under the facts of the case.
Lordship,
We are on the facts of the case.
Lordship,
Your suit has been dismissed.
Lordship,
Your appeal has been dismissed.
dismiss.
There is no pending appeal against the dismissal of the appellate court.
In the High Court
You
pending.
have come only on a revisional jurisdiction.
Lordship.
That's a very, very circumscribed jurisdiction.
Very
You know
limited.
about it.
Lordship, very limited.
You have to take a liberty from the revisional court.
Lordship, what I'm paying that till the eviction, Lordship, at least water connection, Lordship. Yeah,
Sure.
otherwise,
If your claim for renewal of the lease deed has not been found favor by the trial court and the appellate court, then how do you parallelly approach a writ court?
because Lordship, civil suit is pending because till the time they're not
Civil suit
decided.
is not pending at your instance.
Yes, Lordship. There's a
Civil suit is
counterclaim-
pending only because there's a counterclaim.
counterclaim for eviction,
And even if we assume that counterclaim is dismissed, then also you get nothing.
Lordship.
Counterclaim for what?
Counterclaim for eviction,
Ejectment.
ejectment, Lordship. Ejectment it will take time, Lordship.
Sridas, the learned state council has however submitted that from the materials placed on record, it appears that the title suit instituted by the petitioner was dismissed, and thereafter the appeal preferred by the petitioner was also dismissed on 16/11/2022, and presently CRP 189 of 2023 is pending before this court.
140, madam.
140.
Not 120/89.
That has been withdrawn, madam.
140,
Of 25, madam.
25.
140 of 2025 is pending. Full stop. Para. Sri Mohanto,
Lordship.
the learned council has, for the petitioner has submitted that there is a counterclaim for ejectment of the petitioner, which is pending before the learned trial court. Para. Considering the facts and circumstances and also the aspect aspect as to whether a claim of the present nature can be entertained by a writ court when the issue is pending consideration before the trial court, this court this court is of the opinion that while this petition be closed, liberty be granted to the petitioner to approach the learned trial court by filing an appropriate application, full stop. If such an application is filed, the same is required to be decided in accordance with law, more particularly the provisions of the Assam Urban Areas Land Control Act 1972.
72, section 6. Oblige.
I think, but in the ejectment, here the tenant has a right to file an
He
application.
can file an application in the counterclaim also.
Counter claim also, yes, you
Right.
can. Item 8, yes, madam.
May I please your lordship? Lordship, my senior counsel is on leg. Court number 13.
What is the matter, madam?
Oh, Lordship, kindly pass over for time being.
More than 2 children, my lord. At this stage, notice may go, my lord.
Timing today may not be possible, madam. Where is your brief?
Lordship, for some time,
Hmm?
for some time maybe.
Where is your brief? Where is the case records? What are the facts? You tell us the facts.
Lordship, I don't have any idea.
You don't have any idea of the facts.
I have received it today morning only.
You should have read from morning till 11:30, enough time. You can read, you don't need more than 5 minutes to read a brief. Read the synopsis. Where is the brief? Read the synopsis.
That the brief of the fact of the case is that both the petitioner and respondent, number 6, consisted in the Panchayat election 2025 for the post of Anchalik Panchayat member of 15 number Saktola Gaon Panchayat under Kamakhya-Bari Anchalik Panchayat, and the respondent number 6 won the election and elected as Anchalik Panchayat member. After the election result, the petitioner would learn that the respondent number 6 was involved in child marriage violating the provision of Prohibition Child Marriage Act and provided false information and submitted false documents with regard.
Yes, okay, yes, ma'am. What is the remedy?
See, for my lord,
This is Anchalik Panchayat.
yes, my lord. Same man as last month.
Did you approach the secretary? No.
No, I don't think so, my lord.
Hmm?
They have approached the minister.
Minister,
Page 25 is the approach of the minister.
in that case, what orders did we pass? Did we issue notice?
Notice me.
In madam's case,
Yes,
Thakuria?
with liberty to approach the secretary.
Secretary, will pass the same. That would miss, NS Thakuria.
But in this case, Anchalik Panchayat, instead of secretary, BDO man.
Instead of,
Because Anchalik Panchayat, there is no secretary.
it has to be video.
No.
What is the provision? 60?
62 4C.
No, where is regards the Anchalik Panchayat? This is not there.
But maybe it's a Gaon Panchayat.
It's Gaon Panchayat, not. For Anchalik Panchayat is different. That is what we are asking.
Yes.
D.
Yes.
D.
D.
The executive officer of the Anchalik Panchayat.
Yes,
Receipt or information. D,
executive.
huh? You know, NS Thakuria. What is your name, madam?
Yes, Sheikh.
Yes.
Sheikh.
Please give you're not on record.
No, Lordship.
On behalf of MU Mahmood, huh?
Yes, Lordship.
বাকি এখানে এইটো কি লিখিব খালি একে হ'ব হা 62 4D হ'ব আৰু গাঁও পঞ্চায়তৰ নাম হ'ল আৰু ৰেছপন্স নম্বৰ 6 আছে আৰু 15 নম্বৰ
Lovely,
সাকটোলা
Yasmin.
গাঁও পঞ্চায়ত
under Kamakhya Bari, Anchalik Panchayat.
Kamakhya-Bari we will not write. What is the Anchalik Panchayat member? Under the Kamakhya-Bari, Anchalik Panchayat, okay. Baki khini eki, huh? Child marriage. Okay. We are issuing notice returnable which date?
2-2, yes.
2-2. Second. Oh, steps. Right, just a minute. Just a minute.
I am for 1 and 5.
As Dr. 1 and 5,
3, I am and us.
2, Madam,
4, three.
NB Castro for, on behalf of RDB for 2. Then 3 and 4,
And us.
and us. 6 by speed post treated. Steps within 2 working days.
Obliged, Lordship.
Yes.
I live.
So, Mahanta,
Wait, please, your lordship.
unending
Going on, man.
unending litigation.
Yes, this is the situation. They pass an order, just trying to keep it round and round. I say that, well, there are debris, there are unauthorized constructions, you have to remove it. And for that, if necessary, some costs are required to be paid, I will pay it. But instead, they keep on just passing some orders, throwing the blame on me. And therefore, I had to come again. At this stage, Lordship may issue a rule to them. Let the others also appear. And may
Now,
have to-
what is your challenge exactly here?
My challenge is the order at page
18-1, or which one? It's not 18-1.
121.
120.
Order dated 25/2021. Page number 121.
25-1, 24.
25.
25.
Oh, 20, 25.
25.
Okay,
Yes.
okay.
Page 121.
Heard Sri K.K. Mahanta, Learned Senior Counsel, assisted by Sri
I'm sorry.
M. Sekya, for the petitioner who is aggrieved by an order dated 25/2025 passed by the Additional Commissioner GMC. Full stop. By the said order, it has been stated that a decision has been taken against the order of Mayor in Council in the 16th General Meeting of the Corporation. Full stop. It is submitted that as a matter of fact, there is no such order. Para. Let notice be issued, returnable on 2nd of February 2026. GMC, Mr.
I prepare for responder 1 and 2. madam.
1 and 2, as well as standing council GMC 1 and 2. Urban Development, Madam,
5
M. Borman for
and 6 and
3,
5,
3, 5, and 6.
6.
And G. Hazarika for, say, revenue for 4. Extra copies 7, 8, 9, 10 by speed post to CD. Steps within 2 working days.
Right.
Yes, madam.
Lordship, in this case, Lordship, the petitioners are the absolute owner of the land, but the respondent authority wanted to occupy the land and demolish the houses and buildings of the petitioner forcefully without publishing any gazette notification and without giving any compensation to the petitioners, Lordship. And total land is 31 lessons, Lordship.
Annexer 2 series, my lord. If your
Hmm.
lordship come to Annexer 2 series,
Hmm.
it says, therefore, it's a direct purchase.
Okay,
Madam,
negotiation.
Yes, my negotiation.
It is only.
Therefore, you are directed to the APA 12312 before in the office of the circle officer to decide the issue for the purpose of percentage in the land.
Madam, you can refuse.
But
If you refuse, they will go for the acquisition process. This is only as per a scheme.
For 2004.
Yes, Lordship, they wanted to occupy the land
But wait,
forcefully without
My lord,
No, madam, it's not like that.
No, my lord.
Yes.
This 2024, I think
publishing
so.
any notification.
That was 24.
Because
Thereafter-
it says 2004, it can be 2004. My lord, the অসমীয়া কেইখন দিছা নাই?
Yeah.
Yes, my lord, 2024. Vernacular to say. Yes. So, good paper.
Did you agree with the negotiations? Did you agree or not?
They have only given the statement for valuation of the land, but they have not released the compensation. If they release, then it will be.
No,
okay.
it's an acquisition proceeding by way of direct purchase or by the 2013 Act
2013 Act, Lordship.
acquisition.
Acquisition. Under 2013 Act, under section 11(1), there should be publication of preliminary notification before.
Those have not been done.
No, Lordship, they have not done. And
Lord, I'll get the instruction, but no pleading to the effect what has happened after 23/12/2024.
Let us see the first notice, madam.
Yes, Lordship, kindly issue a notice and.
No, let us see the first notice.
Lordship,
Where is the notice?
first notice of Deputy Commissioner, Lordship. Annexer to two series, Lordship.
These are for direct purchase.
Direct purchase.
For negotiation,
For-
for settlement of the issue, Lordship. only.
My lord, there is a scheme, Assam Mala, if I'm not. Assam Mala.
Madam, it's not like that. You have to be properly equipped with the facts to overcome the,
They wanted to demolish our houses, Lordship.
those are not the issue. How do you go ahead with the acquisition? 2013 Act, their process is there, but to overcome that cumbersome process, there is a scheme of 2022 and another of 2023, as per which the parties are given the liberty to go for a direct settlement. There is a committee of the district administration, PWD, revenue officials. You can negotiate. And if that fails, then acquisition proceeding starts. That will save time as well as other impending litigations.
Litigation.
Now, this notice at page 18-17 appears to be an offer for direct purchase. You may refuse that I am not.
Lordship, but on 12th of December, they have come to demolish our houses, Lordship.
We do not know what has happened to this process of direct purchase. What has happened? What have you stated? Mr. Sakya, are you?
Lord, we did not agree with their proposal. What we have done,
No,
Yeah.
you have the liberty not to agree. Where have you stated?
my lord, kindly see in the paragraph 12.
Paragraph 12, page,
Yes, my lord, this is 8.
page 8.
Yes.
Yes.
Number 6. My lord, kindly see, yes,
Yes.
number 6. The circle officer had made a statement showing the village and class-wise present market valuation under Bornagar Revenue Circle. But this is a statement of the village, not of my land. Paragraph 13, that the respondent did not follow the procedures of the Land Acquisition 13 at all, and by force they wanted to demolish the houses of the petitioners as mentioned in the herein above, and without fixation of the value of the land. The respondents have no right whatsoever to take over the land of the petitioner. That on 20. That
No,
on
where have
12
you stated that the negotiations had failed and you had
My lord,
expressed your
that's-
disagreement?
Just a minute, my lord. That on 12/12/25,
Hmm.
the respondents have sent their people along with police personnel and threatened the petitioner to vacate the houses immediately. And they are making all arrangements to demolish the houses standing on the land of the petitioner.
Hmm.
And once they have demolished the residential houses, assembled the houses, so without the due compensation paid the petitioner will be homeless. Now, my lord, kindly see, they did not say that we have agreed. They cannot
no.
prove that, my lord, in their.
Mr. Sakya, they have not come to the court. You have come to the court.
My
On
lord,
the first day, will you say that they have not said that you have not agreed? Where is your statement that you have not agreed?
no, my lord, kindly see, my lord. Paragraph 40.
1-4. We have read this. There is no
No
statement.
hearing was given to the petitioner for the purpose of assessing the valuable land and building, and most whimsically with a malevolent intention, they have decided to demolish the buildings, houses, and destroy. This means we are not agreed. That is, this malady
They have been
implied.
called on 23/12/2024.
It is implied that they forcefully they wanted to demolish the houses, and without making
Why should
payment.
we go for implication?
My lord,
When your entire case is that you did not agree, why haven't you stated that you have not agreed?
This sentence.
We are
itself,
not to go by what will be implied, what will be explicit.
It is true, but my lord, let them notice be issued, let them say that they have agreed. Let them show any document that we have agreed.
That will come only when you say that you have not agreed. When
Yes.
there is no averment as such that you have not agreed, why should they, where is the scope for dispute?
My lord, there may be some omission or commission, lordship, and as such.
No, Mr. Saikia, we are on a very basic point.
My lord,
If the negotiated settlement has failed, you have to state it has failed. In that case, they will go by the 2013 Act.
my lord, just a minute. Negotiation under the scheme, they first, even if we accept, they have to make the compensation first. If without compensation, they demolish the houses, will be a danger, my lord. We have not made any statement that we have agreed. But lordship, if for argument's sake, we have agreed, even then the compensation should be paid first. This is justice, my lord. Justice has to be done first.
Yes, Mr. Das. And they have come to the court after a year. These are of 2024.
14 is said no opportunity of hearing was given. It can't be, my lord, since the notice has been dated, they have been called for.
Okay, heard. Item number. Heard Sri R.C. Saikia, Learned Senior Counsel assisted by Ms. K. Saikia for the petitioners. First of the grievance of the petitioners is with regard to an acquisition proceeding. Full stop. It has been contended that a step for acquiring by direct negotiation though initiated did not end up in any agreement, and the petitioner apprehends their forceful eviction. First the para, let notice be issued returnable on
6 months.
22nd of January. You get the instructions, okay? Or not 22nd. Well, we have it on 28th of January. 28 तारीख. Revenue, Madam. J. Hazarika, 1 and 2. District Commissioner Edition.
3, 4, 5, madam.
3, 4, and 5 by NDAS. And Executive Engineer PWD, anybody is there? Will appear on behalf of D. Gogoi. Watch. H. Borwa on behalf of Sri B. Gogoi, PWD. Sri Saikia, the Learned Counsel, prays for an interim order and has submitted that till now no acquisition amount has been paid to the petitioners. What's the para? Considering the same, comma, it is directed that till the returnable date, comma, status quo with regard to the properties in question be maintained. The aforesaid interim order would, however, be reconsidered after receipt of the instructions. Okay. SCPWD may be reflected in the cost list. Yes.
Extra copies.
Extra copies you have already said. Please find his extra copy. Yes, next.
Wait, not. By this petition, I am challenging the order dated 13 October 2025, which is at page 48. 48. I am a partner, one of the partners of my lord Mahabir Repu. Now, because of the sensational cases, my lord, of these things, one partner being my lord, is also an accused of an offense, my lord, because of the fact, my lord, that my factory has been sealed, which is going to be open on 23rd of September. My lord. Now, if your lordship kindly see, and
yes, what is the status?
the status, my lord, charge sheet has been filed. Your lordship kindly see, my lord, the annex 3. Your lordship kindly see what is the order this is about. Because daily I have to, my lord, incur loss in the plans. I have to give EMI, my lord. I have also applied, my lord, the family members.
Page 48, I have seen lordship the last part.
Last part, kindly said, therefore.
Even then lordship, I have to get the.
You get the instructions. We'll have to have this for motion.
Lord-
Motion on the reopening. Okay.
On the reopening,
Not on exactly on
The
the
lordship,
reopening.
lordship.
We'll have give you one more day on 7th.
lordship.
7th, okay. Heard Sri P. Bora Learned Senior Council, assisted by who's H.K. Sharma, for the petitioner who is aggrieved by the order dated 13/10/2025, whereby the premises of the petition number 1 has been sealed in the pretext of an ongoing CID investigation.
Right.
Full stop. Para. It is submitted that such action is unauthorized and causing huge loss to the petitioner. Para. Let instructions be obtained by Sri H. Sharma, the learned additional senior advocate. Full stop. Let this matter be listed for motion on 7/1/2026. Para. Kindly give, let an extra copy be served upon Sri Sharma during the course of the day.
Just now I'm doing.
You get the instructions. We'll try to.
Lordship.
On 7th, we'll consider. Mr.
Fine.
Paul. आपके बहुत मोशन रहे ढेर मोशन में yes
This matter from yesterday, my lord, I have take instruction of my client, my lord, only received this amount of agricultural zirat, my lord. Not received any amount of this demolition the houses, my lord. My read petition, my lord, page 13, annexure 2, I have annexed, my lord.
for that you can approach the appropriate court if you're aggrieved by the sufficiency of the award.
My lord.
The writ court will not decide
But I have submitted one representation also, that is not.
and you have not disclosed the facts. When was the release made, Madam Bormon?
My lord,
Amount, when was it given to the petitioner?
para 3, my lord, of my instruction.
Which date? 29/11, no.
See, yes, my lord, 29/11/24, and if I see the time station. Transfer course case. Copy 9 number.
The claim is for payment of the Jirat compensation. I is for what, madam?
I am for impleting this respondent number 10, my lord, as per this honorable court order. my lord.
Who's 10?
Kalan. Kalan.
Respondent number 10 is, my lord, additional district commissioner, my lord.
CLA. Then let us pass orders in the I and the matter will come up for motion on the reopening.
Fine.
Okay.
No, it is better, anyhow.
I can dispose of.
Yes.
Okay. Heard Miss Al Wazida, learned counsel for the applicant. You are not on record, madam. Are you on record or not?
Yes, my name is there.
No, I don't know. And Islam and TKD is there.
Al Wazida is there, my lord.
Al Wazida, learned counsel for the applicant, who by means of this application has prayed for implement of a new incumbent as of the following incumbent as respondent number 10. Following incumbent, नाम लिख दीजिए, हाँ? यहाँ से page नीचे ये वाला check करो. Correct. She has submitted that the aforesaid incumbent is a necessary party who was inadvertently left out while presenting the writ petition. Full stop. Also heard Ms. and M. Bormon, London State Council,
I'm
Three
up one
three
to
board
seven,
one.
up to
No,
one to
not
seven,
writing
except two,
respondents, not writing respondent. Then standing council, NHIDCL,
my lord.
and Miss Yoder and Miss G. Hazarika Lane Standing Council, Revenue Department, who do not object to the prayer for implement para. After hearing the learned council and on considering the facts and circumstances, the prayer for implement of the aforesaid incumbent is allowed. I stands disposed of.
Hostile.
Disposed of. In the writ petition, you write, provide an order passed today in I number 4128 of 2025. The following incumbent has been arrayed as respondent number 10. Naam likh dijiye. Learned counsel for the petitioner is required to file amended cost title, whereafter the matter is to be listed for motion.
Thank you, Lord.
Yes, Mr. Gaur.
Well, there to the instruction.
Yes, yes. What is it? What do you say, madam?
You're not here. This is the notice you're not information letter.
Let us issue notice, let us file affidavit.
But my lord, yesterday they demolished my house and they are they will construct, my lord, base for this.
Your lordship,
That you
No.
cannot object, you will be entitled to adequate compensation, that will make an observation.
But my lord, they have to, they have to, my lord, notify, my lord, that
already
There,
like that.
notification is there,
then it's.
it is there. Okay. Heard Sri J.C. Gaur, learned counsel for the petitioners who are aggrieved by the action of the AGCL in
Your lordship, one more, PWD is the main party here. They have not made PWD as party, your lordship.
I'll include me.
AGCL in disturbing the peaceful possession of their land for construction of towers. It has been contended that no acquisition proceedings have been initiated and no notice has been issued. Para, when this matter had come up for consideration on 17/12/2025, instructions were directed to be taken. Full stop, para. Ms. K. Fukan, Learned Standing Council, AEGCL, has obtained written instructions which are placed before this court and has also contended that due notices were served upon the petitioners. Full stop, para. Anna, she has also submitted that Public Works Department is a necessary party which has not been implemented in this proceeding, para. Let notice be issued, returnable on 2nd of February 2026. Revenue Department, G. Hazarika 1, 2, 3, 4, 8 Sharma, AGCL
5 to 8, your lordship.
5,
5, 6, 7, and 8.
5, 6, 7, not 8, 8 is APDCL.
No, sorry, your lordship.
5, 6, and 7, K. Fukan, and I. Bothakur, Standing Council APDCL for 8. Extra copies be served. Para. Sri Gaur, the Learned Council, prays for a liberty. Prays for and is granted liberty to file application for implement if so advised. Para. On the prayer for interim order, while this court is not inclined to pass any blanket interim order, it is provided that all actions taken by the respondent authorities for construction of the towers would be subject to further orders that may be passed by this court.
Your lordship, one more thing, petition is filed by Mahabir Prasad Sharma and affidavit is filed by Balkishan Sharma. your lordship.
He's one of the petitioners.
There are two petitioners.
No, a 6 petitioner.
There are more than
Sorry.
Oblige your lordship.
Okay, this you can take it back.
May please, Your Lordship. Lord, this account freezing matter, my lord, yesterday we served copies upon the council of the.
Yes.
I got the instruction.
Yes, what is it?
Same,
Hmm?
same.
Gandhinagar?
Yeah, yes, this time it's Kerala. And multiple transactions.
What is the kind of suspicious transaction?
Only online gambling.
Online?
Gambling is.
Gambling?
It appears. But we'll file it in affidavit.
We should notice at this stage.
Then, my lord, 7 accepted disputed amount. If the account can be allowed to be operated, my lord.
Not only motioned it.
My lord.
Not only motioned it. How much amount is there?
63,000, my lord.
And what is the amount, disputed amount?
That is the 63,649.
How much amount the account is holding?
Around 27,000 perhaps.
Then how do you secure?
My lord, he also has fixed deposits in that account, my lord.
Fixed deposit is a different aspect.
Fixed deposit, have you made a statement that fixed deposit are not?
No. Here it is not mentioned.
If you are having a difficulty with the fixed deposit, you can come before this court.
Yes.
Very, okay. Heard Sri S. Das learned counsel for the petitioner who is aggrieved by the action of the respondent bank in freezing his account. Full stop. It is submitted that no notice before such action, no notice was issued before such action was taken. Para. Let notice be issued, returnable on 4th of February 2026. Sri S. Datta, learned counsel accepts notice. I have submitted that he would accept notice on behalf of the respondents 1, 2, 3. No, don't say. He has instructions to appear on behalf of respondents 1, 2, 3. Arcady Chaudhary's Deputy J for 4 and 5. Extra copies. 6 by speed post to TD. Steps within 2 working days.
This notice may be also be issued because they have to amend their cause and title. This is Assistant General Manager.
Just a minute, let us.
Proceed.
Sri Datta is required to file the formal power by the next date. Full stop. He has also submitted an instruction that actions have been taken pursuant to directions of the Cyber Crime Cell of the state of Kerala.
Patna and Kerala.
Of the state of Patna and Ernakulam or what?
Kerala.
Ernakulam.
What
the
is
complaint has been raised from one of the police station, which is also.
Then we said Bihar and Kerala.
Our case is from Kerala, man.
Their cases from Kerala, but all the entire cyber thing is-
that the action has been taken, has been initiated on complaints received from the cyber cells of Patna and
Yes.
Kerala,
Hmm.
and the petitioner's account appears to be in connection with the complaint received from the
Kerala. sorry.
from the cyber cell Kerala. Full stop. Petitioner is accordingly at liberty to implead further parties if so advised.
Any date they fix, man?
27th earlier cases.
We have
was-
said on 4th of February.
4th of February. Highly obliged.
Mr. Datta, you take this
Yes, sir.
with instructions. पूर्ण नाम लिखिए एस दत्ता बहुत दासन है सुब्रत नहीं बनती सुब्रत आइटम नंबर 20 yes
My lord, I have taken the instruction, my lord. My lord, they have made a representation before the circle officer with the same, my lord, nature. But that could not be, my lord, retained by the petitioners, my lord, as the made before the deputy commissioners, my lord. Only one document they have annexed, my lord. That is this proposal for the, my lord, allotment of land that is at.
no what had happened on 12/12 That was the purpose we had.
Yes, my lord. On 12th also, my lord, they appeared before the circle officer, but my lord, no decision has yet been taken, my lord, after their appearance. So, my lord, we are apprehending that, my lord, as nowadays, my lord, evictions are suddenly being carried out.
We can pass a similar order which you are doing. If they have filed,
My lord,
you consider, if they have not filed, we grant a limited time, extended time for filing their individual representations along with the documents. And if it is done within such time, you consider within a specified time.
my lord.
Until then, do not evict, and whatever eviction process will do has to be done strictly in conformity with law and the direction of in Salakuddin.
My lord, my lord. And secondly, my lord, they will also consider this proposal also, my lord.
Ah, definitely.
My lord.
That will be part of your representation.
Yes, my lord, already, my lord.
But they have been given time, lordship. 7 days time were given by that, it was fixed on 12, but even then I leave it to alone.
Okay. Heard Sri A.R. Bhia, learned counsel for the petitioners. Also heard Sri H. Das, learned state counsel, also heard Sri R.K.D. Chaudhary, learned deputy SGI, Sri H. Sharma, learned state counsel, and Ms. D. Hazarika, the learned standing counsel, revenue department. Why have you made the Panchayat a party?
Lord, this is, but I don't think, my lord, it is.
Panchayat is not required to be made a
Not
party.
required, my lord.
What's the fair? Considering the facts and circumstances of the case and as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the motion stage itself. Full stop. Suffice it to mention that when this matter was taken up for consideration yesterday, not yesterday, on 18/12/2025, time was granted to the learned counsel for the petitioners to obtain instructions, which she has accordingly done. Para. The writ court has been approached with the following prayer, page 25. Para. As per the facts projected, the petitioners are aggrieved by the eviction process over the land under their possession. Full stop. It is submitted that the land is under their possession since the year 1994. And by the long possession, there is a legitimate expectation for allotment of such land, full stop. It is also the case of the petitioners that in the year 2009, a proposal was mooted for such allotment. Para. As recorded by this court in the earlier order dated 18/12/2025, the stand of the respondent authorities is that admittedly the land in question is grazing land, and the issue of allotment of grazing land would not arise more so in view of the pronouncement, in view of the settled law, more particularly the case of Jagpal Singh versus State of Punjab of the Honorable Supreme Court reported in 2011, 11 SCC 265 over.
My lord,
385.
396.
396. Full stop. In the aforesaid case, the following observations have been made. Full stop. Para. it clearly appears that the land in question is grazing land. First of, though our proposal appears to have been mooted in the year 2009 from the office of the district commissioner, comma, there is no material to show that the proposal has had fructified in allotment of land, full stop. This court is also of the view on the legality and validity of such proposal, which appears to be contrary to the settled law that grazing land cannot be allotted to any individual and can be done only for the community purpose, mainly for agriculture. Full stop, para. In that view of the matter, comma, this court is unable to accede to the prayers made by the petitioners in this case, full stop. At this stage, comma, the learned counsel for the petitioners has submitted that in similar cases, comma, a reasonable opportunity has been granted to the incumbents to show cause along with documents which are to be considered in accordance with law. Full stop. The aforesaid submission, however, has been countered by Sri H. Sharma, the London State Council, who has submitted that time was already granted for making such representation
I'd later dated 3/12/2020.
which is explicit in the notice dated 3/12/2025.
Lordship.
Para. Be that as it may, and by and in the interest of justice and equity, and also following the directions of the Honorable Division Bench in the case of Salakudin versus so-and-so. Is it reported?
Reported.
Please give the report. It is directed that further time.
4 GLT.
Yes, that further time till further time till 26th of December be granted to the petitioners to file their reply to the show cause notice dated 3/12/2025 along with supporting documents. Full stop. The petitioner may also documents, full stop. If such replies are filed within the aforesaid time, comma, the same are required to be considered by the authorities within expeditiously. And in such consideration, the petitioners are required to be given an opportunity of personal hearing. Full stop. If the consideration goes against the petitioners, comma, a reasonable time of further 15 days be granted to the petitioners to vacate the land in question, failing which necessary steps in accordance with law can be taken by the authorities.
Salakuddin is reported in 2024 4 GLT 857.
My lord, only one small submission, my lord. In Jakpal Singh's case, my lord, in paragraph 23, my lord, I have found out, my lord, that the regularization or the allotment can be done in exceptional cases, wherein, my lord, if the land is being used for the public utility on the
Yes, we
land.
have said that, community purpose.
That's why, my lord, this public.
Mainly for community grazing.
But-
Mainly for community grazing.
But my lord, the judgment has not say, my lord, my limited understanding, my lord, is that this utility public, the mosque and the Idgah is also being used for the public utility.
You state this in your petition.
Yes, my lord, I can. Oblige, my lord, highly oblige. Next.
21 is yours, Mr. Bhuya.
My lord. My lord, the notice of my lord eviction is under challenge, wherein my lord they have misconceived ourselves as a my lord encroachers.
Yes.
We are not encroachers, my lord. We are the legal settlers as a Tongia, my lord, cultivators, my lord. My lordship knows, my lord, that there is a provision under the rules that the Tongia farmers and cultivators are given this settlement. And, my lord, to that effect, a document and certificate had also been issued in our favor, my lord, or in the name of the fathers of the petitioners, my lord.
What is it, Mr.
My lord.
Goswami?
My lord, just a minute. In identical cases also, my lord, there were orders passed by your lordship to whatever they want to submit, my lord, to submit before the DFO, my lord, the concerned authority, and they will take a call. Now, here is a case, my lord, they say there was some settlement made by the forest department.
Correct.
But that area was never declared as a forest village, my lord. So in view of my lord, Forest Conservation Act, my lord, they cannot have any claim there in perpetuity, my lord. Even the forest, that earlier there was a rule, my lord, of making forest village. That has also been held to be not applicable after the Forest Conservation Act, my lord. So let them file a representation, my lord. Let them make those points, my lord. We will counter.
My lord, with all respect to my respected friend's submission, my lord, what I respectfully beg to submit, my lord, we are in a forest land, my lord. There is no dispute. And we are also not saying that this is a forest village. My lord, my lordship knows, my lord, in forest areas, my lord, Tongia cultivation and the.
Where is the notification?
My lord, the notification we have not annexed, but the certificate we have annexed, my lord, and there is a proposal, just one document I beg to draw. My
Please,
lord, kindly
please.
turn page 132, my lord.
132.
132, my lord. Six 2019, my lord. Page 132, annexure 9, my lord. This. My lord, herein, my lord, a proposal has been sent from the conservator of forest, my lord, to the divisional forest officer Nagaon regarding conversion of the Tongia Bongaon to forest village. Now, my lord, petition dated so and so.
132. What is 132?
My lord, this
Regarding
is
conversion of
this is
Tongia
a
Bongaon.
letter.
Yes.
Yes, my lord, this is a letter from the conservator of forest addressed to the DFO Nagaon regarding conversion of the Tongia Bongaon to forest village, my lord.
Yes.
Now, my lord, this proposal was made long back on 6/11/2019. In enclosing herewith the petition dated in original received from so and others regarding prayer for conversion of Longjam, Padumuni and 9 numbers of Kheroni, Tongia, Bongaon to forest village. And in this connection, you are requested to inquire into the matter and submit a detailed report on the matter to this office for onward necessary action.
Okay.
So, my lord, this, though it had been advanced, my lord, proposal has been sent, but thereafter it had not been proceeded further. Now, my lord, we are saying that we are in a reserve forest area, my lord, and to that effect, the Tongia certificate. My lord.
Goswami, you you obtained the instructions. We'll have this for motion on the reopening. Still maintain the status quo till then. Okay. Heard 3 A.R. Bhiya, learned counsel for the petitioners who are aggrieved by the move to evict them from the land under their possession. Full stop. It is the case of the petitioners that they are residing in, and it is not in dispute that the petitioners are residing in a forest land. Under which forest?
My lord, Lotumai Reserve Forest.
Under the Lotumai Reserve Forest. Full stop. However, there was a proposal for conversion of the Tongia Bongaon to the forest, to a forest village, and all the petitioners are covered by such a move. Full stop. It is submitted that without the process being brought to a logical conclusion, comma, if eviction is carried out, comma, the rights of the petitioners would be adversely affected. Para? Sri P.N. Goswami, the learned, you appear as what? AG. As AG, representing the Forest Department, has however disputed the proposition advanced on behalf of the petitioners. Full stop. Be that as it may, let specific instructions be taken by Sri Goswami and the matter be listed for motion on 9th of
9th,
January.
9th of-
Para, to balance the equities,
Is it-
comma, it is provided that till the next date fixed, comma, no coercive steps for evicting the petitioners be taken.
Well,
In the meantime, they may file their representations to the notice. my lord.
Let the instruction come, my lord, if we.
Penalty shall not be a bar for the petitioners to
Mal-
file their show cause against the impugn notices.
My lord.
Okay.
Notices dated
My
8/12,
lord,
my lord.
8/12.
8/12.
Highly obliged, my lord, highly obliged.
Yes.
Yes, Mr. Lordship. So the petitioner lordship, this is third round of litigation lordship. In the lordship, earlier round of litigation lordship, this honorable court directed for making face assessment lordship under the acts of 2013. Lordship may kindly come to page 36.
What is your grievance?
My grievance is that although they have, in terms of this honorable court directed, second step lordship, but this, they have not completed the process lordship. And our lands are also.
There will be contempt.
Now, this order lordship passed in 2015. Lordship may kindly come to page
If you
36.
do not approach this court for contempt within the specified time, can you come later for a writ petition?
Because from time to time, lordship, they have taken.
Same cause of action. There cannot be multiplicity of suits for the same cause of action. Certain finality. Again, we will not decide.
They have the, in terms of this order, lordship.
See,
they have-
you had the avenue. You could have come to the court.
No,
1
they-
year is
lord-
passing.
lordship,
2015 order.
lordship,
You tell us, complain before us that the order has not been complied with. We take steps in accordance with
lordship,
law.
they have, lordship estimated the cost and submitted lordship before the authority in terms of this honorable court. Lordship, that lordship will find at page.
So that is what, Mr. Deka, we are trying to convey to you, that if some steps were taken and the order is yet to be complied with, you could have. Yes, Mr.
Because of the limitation, because this order of 2015.
That is exactly which will come in now. How can you circumvent a limitation in a contempt petition by filing a new writ petition? Is it permissible in law for the same cause of action? You cannot circumvent something, a process of law, by adopting a new process. You take instructions. Okay, what is the process? Okay. Third, Sri A.
forward-
Deka, Learned Counsel, for the petitioners who are aggrieved by non-finalization of the process for reassessment of the compensation amount pertaining to an acquisition process. Full stop. It however appears that such reassessment was directed to be done by this court vide an order passed in the year 2015.
11/9/2015.
Passed in the year 2015, and no application for contempt has been filed within the time specified. Para be that as it may, let instructions be obtained by Sri H. Sharma, the Learned State Counsel. Mr. Roy for
For the Union of India Lordship.
Union of India, will it have any role?
Yes,
Yes,
because
because
it
it is
is-
taken by
it
them.
is pending before them. Lordship, for a moment, kindly see page 43.
No, let them your instructions.
4, 5, 6.
By Sri S.S. Roy, Learned CGC, as well as by Sri H. Sharma, Learned State Council, on the steps taken for steps taken pursuant to the earlier orders of this court for list for motion on 9th of January, not 9th.
Lordship, what
We'll have it on 19th of January.
It is definitely on the news.
We'll have sufficient
That
time.
is specifically on the letter dated 7th of January 2017.
17,
But
not
the
saying,
state officer.
I'm not saying anything. I'll let extra copies be furnished to both
Lord,
Sri Sharma and Sri Roy during the course of the day.
Lord.
Yes,
Obliged.
next. Mr. Alam.
Yes, may please, Lordship.
This petition is against the
order of the Assam Board of Revenue, my Lordship.
Lord,
No,
before
let's-
my learned friend starts, the Lordship will find it was filed on 6/12 and it was lying in defect. Suddenly today has become very important for them. There is no urgency as such.
My Lord,
No, they are taking as a normal motion. He has not mentioned it today.
It's true, my lord, but the modus operandi I'm just telling, and your Lordship will find there is nothing. Case is pending before the Board of Revenue.
What is your grievance?
My lord, the petitioner, my lord, he is a, my lord,
Mr. Dotto, there are certain dates when you are required to move bad petitions.
I understand.
Cases without any cause of action.
That's the
So
thing.
this is one of those dates.
Yes, and that's the
Prior
thing.
to the vacation.
I'm indicating that.
my case is good one, my lord.
So he might have chosen this date.
And if your lordship want to hear at its entirety, can it be on 5th? Otherwise, I'm ready even today, but.
We are not inclined, you may be ready. We are not ready to have an extensive hearing on the last day of the
That's
court.
the reason, my lord, in a hurriness, my lord, they want to take some order.
What order?
I don't know what order they can get. I am having my reservation.
Even if they get some order, let them have. Last day of the court.
I don't think your lordship will go to that extent to give an.
What is your,
My
what
lord,
is the relief you are seeking?
My lord, the Assam Board of Revenue, my lord, what has happened, my lord, the initial mutation order was in my favor. It was ordered in the year 2010, my lord. Against the order of my mutation, my lord, they have come before the additional deputy commissioner by way of an appeal, my lord. That appeal was dismissed and in the year 2018. And thereafter they come.
The board has acted so moto.
No, my lord, may kindly come to page 81.
No, the order which you are aggrieved of 28/8/2025.
Yes, my lord. There are two orders, my lord.
Two order and 18/9.
Yes, my lord.
18/9 has been
My lord.
passed so moto.
My lord, what has happened, my lord? This appeal has been filed like in the name of the dead person, my lord. So when we have informed the court that appeal has been filed in the name of dead person, my lord, then a petition has been filed to striking out the appeal number 1 and 2, my lord. So court, my lord, and thereafter this striking out petition was subsequently they have filed another petition, my lord, for amending the cost title. And thereafter, my lord, by the order, my lord, they have withdrawn that application for striking out, my lord. And consequential, their subsequent petition, my lord. And thereafter, my lord, court has considered these both petitions and my petitions regarding maintainability because it is filed in the name of the dead person, my lord, because it is in nullity, my lord. So my, that has not been considered, and my lord, my petition for maintainability was rejected, my lord. And thereafter, my lord, the court suo moto on his own.
Is the proceeding pending?
Yes, my lord. And my lord, my delay has not been condoned, my lord. 1030 days has been delay, my lord. My lord, may kindly come to page 80.
Let them pass final orders, then you come to the court.
My lord, the delay, my lord, not condoned. 148, my lord, may appeal, my lord, without condoning delay, appeal has been admitted. The record has been called, and my lord, now it is fixed for hearing, my lord. My lord, may kindly come to page 81, my lord.
Keeping the delay open, my lord, that order was passed. And
No,
my lord,
how can it be done?
this is covered by
How
the.
can it be done?
My lord,
Without
this-
from where does the board assume jurisdiction?
My lord, I can take.
Without
your-
delay, condoning the delay?
My lord, the
It is
full
a-
bench decision of this honorable court.
Yes, please.
If the honorable court finds, my lord, that there is a satisfaction of there is some perversity, in that case, my lord, they can fall back to section 151 of manual, my lord, land revenue manual.
Let
And
us
my
see.
lord, your lordship, I'll just paste the decision of the appeals court. I mean, this honorable court in full bench decision.
Yes, please.
Need to go.
Which one?
Wait, side of the. My lord, 77 SCC on.
No, that is a paragraph.
Paragraph 17, my lord.
17.
Yes. In 53 ILR Assam 532, an appeal was presented to the Revenue Tribunal under section 147 of the regulation against the grant of patta. The appeal was barred by time. The tribunal, however, interfered in the exercise of its divisional jurisdiction and reversed the order of settlement in favor of the grantee. The grantee filed a suit for declaration that the order of the tribunal was ultra vires and without jurisdiction. The tribunal did not extend the period of limitation for the appeal. It was contended that the right of appeal had been lost by a flux of time. The tribunal exceeded its jurisdiction, rejecting the said contention. It was observed as follows. The section 151 of the tribunal had the power to call for any proceeding held by any officer subordinate.
151 of what?
151 of Assam Land Revenue Regulation.
Hmm.
I'll just take your lordship to that. Your lordship may kindly see 151.
Yes.
The board, a deputy commissioner, a settlement officer and a survey officer may call for the proceeding held by any officer subordinate to it or him and pass such orders thereon as it or he think fit. Now, my lord, in going through it, then your lordship can see the note. An order once passed in any case cannot be revised either way. This is not that important. Now, my lord, when the board finds that there is some irregularity, a substantial irregularity, they can so much to call for the record. Now here what happened, my lord, the mutation was done by, my lord, as your lordship understands, by fraudulent means and all that, without any document of gift. Now they say it has been gifted to him. Where is that instrument?
When is the hearing fixed?
My lord, the hearing was fixed on sixth, huh? Sixth of
On
January.
6th
Next
of
date?
January. my lord.
6th of January, my lord.
So
Let,
let hearing be conducted.
let the hearing be deferred.
Your lordship may hear it at its entirety.
We will do it. We'll direct the tribunal, board not to,
Yes, yes, that.
on,
that
on
will be done.
6th, yeah, otherwise it will be infractious. You may have a good case. Because while exercising 147, 151 can also
Yes,
be
yes.
read as a part of the appellate
That-
jurisdiction.
51, right.
And, okay, we'll consider, okay. Third, Sri G. Alam, Learned Counsel, for the petitioner who is aggrieved by a proceeding before the Assam Board of Revenue in case number 64 RA within bracket L oblique 2023, full stop. Amongst others, it has been contended that the appeal was barred by time. And without condoning the delay, the appeal has been proceeded with, admitted, proceeded with, and the hearing is fixed on 6.
The delay has been kept open, maintenance.
Fixed on 6/1/2026. Correct? Sri S. Datta, Learned Senior Counsel. Appearing for the
My lord, the respondent.
all the respondents.
Yes.
No, cannot be all the respondents.
Yes, two respondents.
Respondents are there.
Where appear.
Mr. What is this, Mr.? Where is the ABR? It's a writ proceeding.
They have to make them party meal.
We are not an appellate jurisdiction or revisional jurisdiction.
My lord, I will implement them.
ABR has to be a party, adjudicating authority.
My lord, my lord.
It's a decision-making process.
My lord.
We are questioning or examining. You are questioning or
My
examining.
lord. I-
If the party is not here, who will defend?
My lord, I will file the IF.
For the respondent numbers 1 and 2, key. Appearing for respondent numbers 1 and 2. Are you on caveat?
Yes.
Yes.
Oh, there's a caveat.
Caveat.
Okay, well, has however submitted that the aspect of delay is kept open, which should be taken up in the final hearing. Full
Right.
stop. He has also placed reliance on a full bench judgment reported in AIR 1977, Guwahati 83, named Satya Ranjan Paul Mazumdar versus Assam Board of Revenue. Full stop, para. This court, let notice be issued returnable on, we give a date. Returnable on 21st of January 2026. We are only calling for scan copy. We are not calling for the records.
Right.
Otherwise, we'll stay everything.
Yes.
Call for a scan copy of the records from the learned board, learned ABR. Full stop. Three, your full name, please. You can forget. Name?
Siddhant Datta.
Sri Siddhant Datta, Learned Counsel, assisting the senior counsel, accepts notice on behalf of both the respondents. Let extra copies be served upon him during the course of the day. Full stop. It is, however, noted that the learned ABR, Assam Board of Revenue, has not been made a party respondent. Para. Sri Alam, the Learned Counsel, prays for and is granted liberty to file appropriate application for implement of necessary parties. Para. Sri Alam, the Learned Counsel, prays for an interim order, which, however, is opposed by the Learned Senior Counsel for the respondents. Para. Without going into the inter se merits of the dispute, to balance the equities, it is provided that the hearing slated on 6/1/2026 be deferred till further orders. Full stop. Appropriate further orders to be passed by the court on the returnable date.
Much obliged.
You file your application,
I'll
Mr. Alam.
I'll file.
You write at the, this thing, caveat. Heard Sri Sishi Dutta, learned senior counsel assisted by Sri Siddhant Dutta for the caveator. Caveators who have lost this caveat in connection with Revenue Appeal number 64 RAL Sailabaha of 2023 before the learned Assam Board of Revenue. Where the caveators would be heard in the event this court proposes to pass any interim order. Caveat stands discharged.
Right, madam.
I appear for the petition.
Yes.
Actually, here we are challenging a total illegal search operations which commenced at our premises on 17th of this month. Lordship, I'll just take 2 minutes to give the background. Lordship, I am under the central GST jurisdiction. When GST came, Lordship, there was an allotment of taxpayers basis of GST Council circular, wherein some taxpayers were allotted to center and some taxpayers allotted to state. My allotment was done under the central jurisdiction. So, Lordship, for all the purposes of scrutiny of returns, audit of books of accounts,
Yes.
I am assessed by the central GST. Central GST department for the period 17-18 to 22-23 had conducted an extensive audit of my books of accounts. Certain liabilities were determined and the entire liability stood paid. Now, Lordship, for the same financial years in 2022, the state investigation wing came to us. We provided all the books of accounts at that time also because it was an investigation action, and they issued us a show cause notice on in February 2025 for the period 17-18 to 2021 regarding some input tax credit. They say you have irregularly availed. We came before this honorable writ court, and this honorable writ court has stayed the further proceeding under that particular show cause notice. Now, Lordship, on 17th of this month, under the garb of search operation under section 67(2) of the Act, certain officers of the state enforcement wing came to our premises and they handed over a letter under the name INS 01. Lordship, that INS 01, I have annexed a copy at page 149. Lordship, INS 01 is an authorization given by the additional commissioner or the joint commissioner for the purpose of inspection or search. There are two provisions under the Act, Lordships. One is section 67 subsection 1, which is an inspection, and an inspection can be converted into search under 67(2). In my case, Lordships, the authorization directly spoke about 67(2). There was nothing called as inspection. The authorization given by the additional commissioner was directly for search.
Yes.
Now, Lordships, then on the same day, they give us one letter, which is at page 150, Lordships. That letter starts with.
Now, what do you expect today?
Lordship, I expect to, Lordship, I am arguing today before your lords. Still, what they are doing, 17 they came, they left. Tomorrow again they came, they left.
Yes,
Today
Mr.
they are again coming.
Mr.
Lordship, search operations.
Yes, that's a minute. Yes. What is it?
In fact, my lord, this page 150 Lordship will see.
Yes. No, if we did not get your name.
That submission, then my lord, it is without authority, my lord.
What is your name? Your Kanodia.
Kanodia, Lordship.
Mr. Kanodia, you are contending, he is contended that there are two aspects under 67. The first is the inspection followed by a search. Without there being inspection, you had gone for a search.
My lord.
And they are impending the further move is apprehended.
Already the periods which have been done.
That I dispute, my lord, so far as the period is concerned, my lord. It's not from that period. And further, my lord, search and seizure is not, my lord, connected to audit and all, my lord, whatever is done in the earlier stage. That's a separate issue. Both are separate proceeding. There is nothing in the statute to show that, my lord, if it is done, audit is done, then, my lord, search and seizure cannot be done in a separate proceeding.
No, search and seizure by the state GST
Yes.
is under what purpose? What provision of law? And what is the objective?
Objective, my lord, that lordship will find in the provision itself, lordship.
No, what is it connection? Why you are?
Yes.
Why is it done?
That, my lord, page 149.
149.
Yes, my lord.
We have just seen 149. Yes.
Yes. It
Yes.
says, my lord, the region sir that has suppressed transaction relating to supply of goods and or services, has claimed input tax credit in.
But won't this come under the? We're just asking a question.
Lord.
Won't this come under the purview if they are covered by the CGST.
No. My lord, so, my lord, for the purpose of, my lord, enforcement of just a minute, my lord, I'm proceeding. Yes, my lord, for the purpose of intelligence-based enforcement action, my lord, be it under CGST or the, my lord, state GST. The authority has the power.
What happened on 1712?
1712, my lord. Lordship will see, my lord, we have given them a notice.
Now this notice at 149 and 1612.
Yes, then on 1712, my lord, when we found nothing, my lord, there is no books of account in this particular premises, my lord, where it is a registered office in our state. Lordship will see page 150. We have given details, my lord. We are seeking for some, my lord, information, some justification, documentary evidence and all. They are not cooperating, my lord. It's an investigation stage, my lord. Page 150, Lordship may kindly see. These are all
When are you proposing to again visit them?
My lord, only thing I would request, my lord, that the Lordship will or direct them to, my lord, at least cooperate. The authorities may not come there. Some authorized person can come, my lord, they can, my lord, furnish all these documents.
Lordship.
Why they are signing to, my lord, provide this?
Page 150, my learned friend showed, kindly sees the language. Lordship, 150, during the data analysis of profile, return and other data available. This is the work which is to be done by my proper officer. And Lordship, Supreme Court in Armor Security, Lordship, I'll just hand over the judgment. It was delivered recently, when the Supreme Court had told that all the return-based action cannot be done by investigation wing. Lordship, I kindly take this for once. The last para at page 61 of the judgment, the conclusion of the Supreme Court. Para 96.
Para 96.
Page 61, Lordships.
Yes, please.
Lordship, 96, we summarize our final conclusions as under.
Yes.
Clause B of subsection 2 of section 6 of the Act and the equivalent state act bars the initiation of any proceeding on same subject matter. Any action arising from audit of accounts or detailed scrutiny of return must be initiated by the tax administration to which tax is assigned. I stop here, Lordships. Now, Lordships, kindly take page 150 for the moment. 150.
Of the
writ.
Okay.
Of the writ, Lordships. What they say, during data analysis of GST profile, returns and other data available, they are an enforcement wing. And Lordship, kindly sees the table. In the table, they are saying inward e-way will not reflecting in 2A. All these are my return-based scrutiny, which already my proper officer is the CGST department. And up to 22-23, he has conducted a detailed scrutiny and audit and closed. Again, and Lordship, in the garb of a search operation, they are asking for this. It was a roving inquiry, Lordship. The proper officer who has come, he is giving interviews in media. I have the YouTube videos. He is giving interviews in media, and Lordship, he is liking the media post. The officer who is at present in my office.
Not required. Not required.
Lordship, and there is a threat, Lordship. There is an open threat stating that yes, you call somebody from your office and otherwise we will take appropriate actions. Lordship, first, there is no authorization under 67(1). They say, they write in their letters, inspections or seizure, but there is no inspection.
Okay, we'll issue notice, take instructions.
Lordship, yes, my lord. My lord, only thing, my lord, let them cooperate, my lord. So,
We halt for the time being.
no, Lordship will see 97, 96, my lord, Roman 3.
Of
that, my lord, judgment here does not place.
90?
Para 96, Roman 3.
Page.
Page 61, with the, I referred the judgment, the same judgment, para 3.
No, para 96, Roman 3, my lord.
Roman 3, yes.
Conclusion. Intelligence-based enforcement action can be initiated by any one of the central or the state tax administration, despite the taxpayer having been assigned to any other. Well, there's no bar, my lord. This is the finding of the Honorable Supreme Court. And my lord, why they are not cooperating? In fact, my lord, there is, in this very judgment, the Honorable Court has held that, my lord, the authorities, the
page 150.
Dealers must, my lord, cooperate.
It is everything based on my returns. There is no enforcement activity. They say this e-way bill data is not matching.
Mr. Gogoi, on a reading of 150,
my lord,
can you link with any activity which you can relate with intelligence-based enforcement action?
Yes, my lord.
Where?
I have, my lord, yes. Let me place the proceeding itself. I have to what a copy, my lord. File one affidavit is a different thing, my lord. The very process was initiated. Copy to go. Second review.
Have you filed your affidavit?
No, no.
This notice, no motions.
Lordship will see my lord one.
First.
Lordship will see my lord page number. This is the my lord, from the records I'm
What
showing,
is this? What order sheet is this?
my lord, of the entire proceeding of search and seizure, prior to that, what has happened, my lord? Very first note, my lord, 10/12/2025. Just notice was issued on my lord, 16/12. So before that, lordship will see what is the my lord. Page 10, my lord, 10/12/25. On the basis of the actionable intelligence inputs get generated, my lord, everything has been detailed.
Heard.
Only thing, let them cooperate, my lord, we
Yesterday
will
we
not
have given-
take, my lord,
we
we
have
will
given-
not take any coercive action, but investigation must not.
I'm not asking for stopping. Yesterday I have given them a
That's-
letter also seeking some time to furnish all the data. This
Then
is
my
not
lord,
record.
lordship will give us a fixed
But
date when
Lordship,
they can
par-
appear and.
Lordship,
furnish.
parallel proceeding cannot be allowed till 22-23. I am not obliged to give them any data, Lordships. To that extent, your Lordships, I need a
Heard Sri A. Kanodia, learned counsel for the petitioner. Full stop. The grievance of the petitioner pertains to a proceeding initiated by the state GST under section 67 of the Assam GST Act of 2017. It is contended that the business of the petitioner is covered under the central GST, under which extensive audits have been done and all liabilities have been discharged. Full stop. However, a show cause notice was issued by the state GST. Full stop. It is submitted that on 17/12/2025, search was done.
search was, it was
Search.
67-2,
Search was done
not 67.
under section 67(2). Full stop. It is also contended that without undergoing the aspect of inspection, comma, such search has been done. Full stop. The learned counsel has fairly contended that that matters relating to any investigation would not be objected to by the petitioner, and their only concern is with regard to the compliance of the law holding the field, and in which the respondent authorities are required to follow a fair procedure. Full stop. Para. Three, let notice be issued. Returnable. We give a date. You're an obsession counsel. You tell us a date when?
Lordships, after first week of January, after.
Second week we have a break. We
Lordships.
can have it on 19th,
My lord.
Monday,
Lordships.
19th of January 2026. You are for all or Union of
No, the
India?
union is there, my lord.
3B.
Lordship, kindly to give on 21st, 19th, I will be at.
21st, okay, no problem. 21st. 21st, returnable. 3B Gogoi. You appear as Mr. Gogoi as
My lord, as additional agent. only.
additional AG accepts notice on behalf of respondent numbers 1 to 4. 1 to
4.
1 to 4. No, 5.
No, no.
5 also.
1 to 7, my lord.
1 to 7. Extra copies.
6 and 7 is GST.
Oh, 6, 7. 1 to 5, my lord.
1 to
Sorry,
5.
1 to 5.
6, 7, 8 you'll take. Speak agent. Learned counsel appearing on instruction of 3 SC Kyle. Learned standing counsel CGST for 6, 7, and 8. Para. Let extra copies be served. Para. 3. The learned counsel prays for an interim order, which is opposed by the learned
My
standing
submission.
counsel. Full stop. Para. Considering, the learned standing counsel has also placed before this court materials to show that the basis of the present action is intelligence input.
And not
Full
only
stop.
that, my lord, under provision of.
Considering
Subsequent law of
considering
1967.
the law holding the field, including the judgment, recent judgment dated so and so, past dated
Yes, reported, no.
Dated
Dated
14th August
14
2025.
8 2025 of the Honorable Supreme Court in the case of it is provided that while there would not be any blanket order of stay, comma, no coercive action be taken against the petitioner, which will, however, cooperate with the investigation in accordance with law. Full stop. The aforesaid interim order would, however, be reconsidered on receipt of the instructions on the returnable date.
Lordship, I have asked for some time to the department, my letter, Lordship.
Okay.
That may be.
Yes, how much time?
30 days I have asked because they are asking 4-5 years data. Again, they are asking 20. Lordship, my prayer today, Lordship, 20 up to 22, 23. If I give them data, it will be totally parallel proceedings. 23, 24, 24, 25. I am ready to give documents, Lordship. For that, I have sought 30 days. Lordship may direct 2 weeks. I will try in 2 weeks. For first 2 years, Lordship, I may be.
The petitioner, Sri, on the further prayer made by the learned counsel for the petitioner, comma, 2 weeks further time is granted to the petitioner to submit the documents pertaining to the issue involved. We're not specifying the time.
So financial year, Lordship, in that case, Lordship, then Lordship, 20 up to 20 to 23, CPSP conducted the audit, Lordship.
Whatever he wants to submit, let him
Lordship,
submit.
then Lordship, then kindly make it 4 weeks. For the document, because 4 years, Lordship.
3 weeks. 3 weeks. 3 weeks. 3 weeks.
Grateful dear, Lordship. Much of Lordship for the consideration because we mentioned before your Lordship.
Yes.
Grateful dear.
Yes, next.
25.
Yes.
Page 13 to 16, my lord. My lord, the contention of the petitioner is that.
Rutumai, this.
Yes, ma'am.
My lord, if I may submit, my lord, altogether 21 cases were listed today, my lord, are listed today. 10 were listed before court number 15, my lord. An order has been passed disposing of the exactly identical, my lord. So same notice also. Allowing them to file representation for within 7 days. Then 15 days to.
Same thing which you had
Then
passed.
15 days will pass an order.
Pass.
And then, my lord, till then status quo to be maintained. And finally, my lord, if no representation is filed, we are at liberty to proceed with the imprint.
Yes, that is the order we are also
Yes,
passing.
that has been passed by them. Same
Okay.
exactly. It is.
All the cases.
Here, item 25, 27, 29, 30, 31, 32, 33, 34, and 39.
Because
37.
No,
39.
not 37.
item number get a please. 37 also. Please give the numbers again.
My lord, 25, 27, 29, 30, 31, 32, 33, 34, 39.
37 also.
37 of my demand. All these cases being analogous. Are heard together and are being disposed of at the motion stage itself, full stop. The learned counsel has also agreed on the aforesaid course of action, full stop para. The grievance of the petitioners is with regard to an eviction notice
Dated 21/11/2025.
21 dated 21/11/2025
Pertaining to
issued by the Forest Department, issued by the DFO,
Nagaon.
Nagaon, full stop. By the said notice, the petitioners were directed to produce the documents to support their position within a period of 15 days, failing which they are to be evicted from the said land. Full stop para. It is contended in the bar that the petitioners in these cases, have you filed? No, not filed.
They claim better but not annexed.
Representations.
It is contained in the bar that though the show cause notices have been replied,
We have submitted representation.
that representations have been filed which have not been considered.
Yes,
Tara?
ma'am.
Sri Goswami, the learned. Oh, no, that's what I have heard. I have heard Sri so and so and so and so and Sri so and so. Goswami for all?
All.
AAG for all, huh? Done. Sri Goswami, the learned AAG has submitted that adequate time was granted to the petitioners to show cause which which does not appear to have been done. And the land in question.
There is my submission.
And the land in question are reserve forest land. Full stop. He has emphasized the requirement of making all forest land encroachment free, which is also the mandate of the Honorable Supreme Court. Full stop. Para. The learned counsel for the petitioners have, however, disputed that they are in occupation of any forest, reserve forest land, and have also stressed that since a long period of time they are in such position. Para. Considering the rival submissions and balancing the equities, it is provided that if no reply to the show cause notice,
Let them file fresh, my lord.
if no reply to the show cause notice has been, irrespective of whether any reply has been filed earlier, let fresh replies be submitted against the show cause notice within a period of
7 days from today, my lord.
we'll give the date. Within today is
Today is, my lord,
within 2026,
my lord.
12/20/25, along with documents. If such replies are filed within the specified time, the same are required to be considered expeditiously, in which the petitioners be given an opportunity of personal hearing. Full stop. It is made clear that in case the replies are not filed, the respondent authorities would be at liberty to proceed in accordance with law. Full stop. It is also provided that in case the consideration goes against the petitioners, further 15 days time be afforded to them to vacate the land in question, failing which the authorities would have the liberty to take action in accordance with law.
My lord, I think 47 notice lastly issued on 8/12, my lord.
8/12.
He has to reply, my lord. 8/12 is very fresh, my lord.
8/12.
And before that, another notice was issued.
Notice to /8/12. Earlier was 8 what?
8/10, my lord. Earlier was 8/10.
8/10 and 8/12.
My lord. Obliged. Obliged.
126.
26 Mandal.
Lord, we have challenged the Lord speaking order that your lordship will find at page 18.
Speaking order by?
Page 18, my lord.
Speaking order passed by whom?
My lord, the additional district commissioner Dubri, my lord Kala.
Then there is a remedy, I think.
Yes, my lord, we have filed application also. Lordship will find.
Application for?
Page, my lord, 26 for, my lord, enhancement under section 64 of the act. That is pending.
Yes, what do you say? This acquisition is under the 2013 Act.
13.
And you are aggrieved by the award.
Award.
And you have filed an application for making a reference under 64.
64.
Not been acted upon.
Not been acted upon.
Yes, madam.
Lordship may fix it on reopening. I will have the instruction, my lord, regarding.
Or you can issue notice also.
Lordship.
Heart Sri M.U. Mondal, learned counsel for the petitioners. Full stop. It is projected that lands of the petitioners have been acquired.
Land, it is not the land, my lord, the Roham bricks industry. We are not for the land, we are for the Zirat.
That certain acquisition proceeding has been made, which has affected the brick industry of the petitioners. And such acquisition has been made under the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. In respect of so-and-so. It is also submitted that application for making a reference under section 64 of the Act has been made, which has not been acted upon. Let notice be issued returnable on on 13th of, on 9th of, not 9th, 19th of January 2026. Revenue Department, Madam, want to two only. District M. Bormon for GA for 2, 3. Here for 1, sorry, 1 for 1. Then Bormon for 2, 3, 4, 5. Who are the private respondents?
They are not interested person, their name included in the award. So they have been made part.
Extra copies 6 to 9 by Speed Post AD. Steps within 2 working days.
Till then, no disbursement to the private respondents.
That can be 3. Mondal, the learned council prays for an interim order. Para, after considering, it is submitted that any disbursement made in the meantime shall be subject to the outcome of the writ petition full stop. It is further observed that pendency of this writ petition shall not be a bar for taking action in accordance with law on the application filed under section 64 of the Act.
Diplomacy.
No? Accordingly, that's what we want. Oh. Oracle the was in that various meeting was it. No. Full before the content. That was. Okay, we'll sit in the second half. Okay, maybe at 2:10.
This I have challenged order dictated 2nd of September 2005, 25 Lordship and Action 9. A plot of land was allotted to Indian Red Cross Society, Sri Bhumi District Branch Lordship in the year 1991. And there is a series of communication between the government and the Red Cross Society Lordship. And there is some tenant as well as one club is inside that plot of land, and they were the permissible occupier and one tenant as per some agreement as well as some suit was filed against us. Now they agreed that they will be the tenants under the Red Cross Society.
Yes, Mr. Das. Who's the respondents here? Who are the respondents?
Lordship, it was responding.
But Sri Bhumi Development Authority is a statutory authority, isn't it?
Statutory authority.
Why have you made the chairman a party by name?
By name because he is doing also a illegal activity, Lordship.
On his behalf.
On his behalf, because he is the president of the state one Vijay Sangha Club, and he issued notice to us an Action 9 Lordship. Subsequently, when we asked for the complaint, kindly
Okay, heard Miss M. Dev, Learned Counsel for the petitioner, who by means of this application has put to challenge a notice dated 2/9/2025 issued by the respondent number 4 with the intention to grab the property of the petitioner society. Full stop. The grievance is also with regard to a direction for stopping of work. Correct?
Yes, Lordship.
Let notice be issued, returnable on 30th of January 2026. Revenue, yes, Madam Pierre Mahanta for 1.
I'm 2, 3, 4.
2, 3, and 4 by NDAS. 5 by Speed Post with AD. Steps within 2 working days extra copies, no? Sri and Miss Dave, the learned council, prays for an interim order. Stop construction, how do you, are you constructing anything?
First floor, ground floor already constructed by the Vijay Shankar Club itself.
No,
But
no,
when
no,
I was
after
started,
considering, it is directed that till the next returnable date, no coercive action be taken against the petitioner society.
no coercive lordship,
Because you apprehend of your grabbing of the property also.
yes, lordship. And he is the.
No,
he is the-
no coercive action be taken against the petitioner and no third party rights be created in respect of the property in question.
Obliged, lordship.
You take the instructions. We find that the private respondent is the chairman of an authority.
Yes, ma'am.
There may be some statutory backing also.
Yes, sir.
Okay, next.
Obliged.
Item 35.
Mr. Boragohai,
The petition pertains to challenging the impugn orders of the Central Information
you
Commission.
have filed this afresh.
Yes, your lordship.
Heard Sri H. Boragohai, learned counsel for the petitioner who has put to challenge the orders of the Information Commission, including the second appellate authority, whereby the information has been directed to be shared,
Your lordship.
to be given.
The second appellate authority is the petitioner itself, your lordship. The bank.
A commission by which the petitioner has been directed to share the information sought for by the respondent number one, full stop. It is submitted that such information pertains to third party.
Third party, your lordship.
Full stop, para. Let notice be issued returnable on 4th of February 2026. Let steps be taken for service of notice upon the respondents by hit post with AD, para. 3. Boragohai. Sir Boragohai, learned counsel for the petitioner, prays for an interim order, para. Considering the facts and circumstances and the nature of the challenge, and by balancing the equities, it is directed that till the returnable date, the impugned direction dated 21/11/2025 shall remain suspended.
Deeply obliged, lordship.
Similar here, we have challenged the impugned election, held on the 29/11/2025. The election was held beyond the time, my lord, and not completed within the time. The lordship may kindly look into the annexure 3 page 35.
Elections were held when?
Election was held on 29/11/2025. So
Where
it is beyond time.
You are so late.
Yes, your lordship.
No, examining is not a problem, but you are asking for a stay order also.
Yes, my lord.
Okay, we'll examine. Heard.
Lordship, I am
Read.
hearing for the caveat.
Is there a caveat? Okay,
Lordship, they should go under Rule 27, your lordship.
okay.
Election already held, your lordship.
But it's a beyond time,
Let
Not
the
maintain-
register decide, your lordship.
not maintainable.
Heard. Item number?
In fact, they have an
36.
alternative remedy, your lordship, under
Okay.
section 111.
Okay.
And some party has already made a complaint and the hearing is scheduled to be held on 22nd of December.
Okay. Heard three, sorry, learned counsel for the caveat, who has lost this caveat, an order dated 12/12/2025 passed by the Assistant Registrar of Cooperative Society, Silchar, whereby the caveator, along with other members of the Board of Directors, have been whereby the elections of the caveator and the other board of members have been approved.
Approved.
The caveator would be heard in the event this court proposes to pass an interim order. caveat stands discharged per remain hereby. Heard, Sri Sina, B. Sina, learned counsel for the petitioner, who has put to challenge an order dated 29/11/2025 of Constitution of the Board of Directors of the Gumrah Cooperative Society
Limited.
in the district of Kachar. Full stop. Clara. Let notice be issued, returnable on 4th of February 2026. Corporation Department, Ms. So Standing Council, Corporation Department for 1, 2, 3, 4. And 5, who will take? You take for 5.
I am for respondent number 20.
28.
20.
Caveat. Anil Das.
Anil Das.
And Sri So Land Council for the caveat for respondent number 20. Extra copies. Then steps for 6 so by speed plus PCD. Steps within 2 working days. Okay.
Now the interim pair may be considered next date.
What interim period may not be maintainable. The learned counsel for the respondents has raised an objection regarding.
Because it
we have
election
only
time.
raised an objection regarding maintainability of the writ petition. Including amongst others on the ground of availability of alternative remedy.
Obliged, Lordship.
May I please, Your Lordship? This is the case, Your Lordship.
Caveat.
Caveat is there.
What is your name? Caveat. Name.
I am for P. Das, Lordship.
What is your name?
G. Das, Lordship.
Heard through G. Das, learned counsel for the caveat, who has lost this caveat qua a judgment and order dated 18/9/25 passed by the learned Assam Board of Revenue in case number 87 RA within bracket K/2023. The caveat would be heard in the event sense. Caveat sense is charged.
Lordship, I have two submissions, Lordship.
We have not even heard. Let us first hear.
Is Lordship, because, okay. May I please, Your Lordship? This is a case, Your Lordship, where Your Lordship, the petitioner has put to challenge order of the Board of Revenue, Your Lordship, whereby Your Lordship, my name, Your Lordship, which has been in existence since 1974, Your Lordship, has been directed to be cancelled from the Khotian, Your Lordship. Now, what has happened, Your Lordship, while passing that order, Your Lordship, the learned Board of Revenue did not take into account the fact that, Your Lordship, when in the place of the, Your Lordship, respondent number 567, predecessor in interest of 567, name was cancelled and my name was incorporated in the Khotian, Your Lordship. There is an appeal filed by the predecessor in interest of respondent number 567. And in fact, if Your Lordship comes to page 30,
Yes.
page 30, Your Lordship will find.
Yes.
By the order.
Appeal before whom?
Lordship.
Appeal was before?
Board of Revenue.
Okay.
Lordship.
The predecessor in interest of the private respondents. had
They,
filed.
no, that need not Board of Revenue. They have appeal before the settlement officer, Your Lordship, against the order of the ASO, Your Lordship.
Yes.
Lordship. Your Lordship may kindly come to page 30. Your Lordship will find by the order dated 29/12/75 passed by the settlement officer in case number so and so, the appeal filed by Amjad Ali.
Yes.
Who is the predecessor in interest, Your Lordship, against the Abdul Bari is dismissed and the order dated so and so passes, ASO is upheld, Your Lordship. Now, Your Lordship, this aspect and this has never been put to challenge by them in any of the forum, Your Lordship. And the Honorable Tribunal, Your Lordship, the Learned Tribunal, Your Lordship, while passing this order, has completely overlooked this aspect of the matter, Your Lordship, and ultimately passed this, Your
What
Honor.
kind of interim order are you expecting?
Lordship, Your Lordship, revenue records should not be corrected, Your Lordship, in the meanwhile. That much, Your Lordship, not more than that, Your Lordship.
Who is in position?
Possession, Your Lordship, we have all along been in possession, Your Lordship.
Finding of the revenue board is totally different. In otherwise, contrary to what my learned friend has submitted, page 78 for timing manner.
No, what he has said that there was an earlier proceeding
My lord.
wherein the name of the petitioner was
Yeah.
substituted in place of the predecessors of the present respondables 5, 6, and 7.
Lords, if your lordship comes for time being 78,
Yes.
last para,
Yes.
14, is said this order is passed without prejudice to any remedy that may available to the appellants under the law if they can establish lawful tenancy afresh in future. So my lord, question of interim, my respectful submission will not come now, my lord.
But,
Moreover,
if-
moreover, my
if-
lord.
If there is a change in the Khatian.
No, my lord,
what will
it's
we do?
out subject to the outcome of this petition, my lord. It's still pending, my lord, before this honorable court. It also says, my lord, the learned ADC were recognizing the appellant as tenants, recorded that they failed to prove cultivation and continuous possession over the bulk of the suit land, which is one of the precondition and for conferment of ownership right under section 23.
No, that's.
23 of the 71 Act,
Lordship, 71.
or
actually.
Tenancy Act.
Lordship.
Tenancy.
I am, your
That is
lordship,
the precondition, my lord.
You are
ownership,
not in cultivation.
no, your lordship, ownership, right, I
But
have,
if there is a finding of fact that you are not in
No, your
cultivation, that
lordship,
is a pre-requirement.
that's why your lordship,
We
I
thought
have,
it's on something else.
your lordship, I have annexed your lordship.
You are
certain-
the tenants,
Yes, your tenants,
riots,
riots, your paid.
and you applied under 71 Act.
Initially, your lordship, when we applied under 71 Act, under section 23, the matter ultimately came up before this honorable court, and this honorable court, ownership right was granted to us. Then your lordship, that was put to challenge before the Board of Revenue. Board of Revenue set it aside. Then we came before this honorable court. Honorable court passed an order to file a fresh petition before the additional deputy commissioner. In
Under
that-
71 Act.
Yes, we filed it. When we filed it, additional deputy commissioner says this does not grant us ownership right, but upheld us as a Khotian holders, your lordship. That is your lordship, that they have put to challenge before the Board of Revenue, your lordship. So far as our right is a Khotian, that is the order passed by their authority, your lordship. And that is put to challenge before the Board of Revenue, and Board of Revenue while passing, it has gone, it has.
Okay, what do you say, Mr. Das?
My lord, I lift your lordship.
No, Mr. Das.
Since he is a caveator, my lord.
Where is the operative part of the impugned judgment?
Lordship will kindly come to page 80, your lordship.
80 move yana kinda.
80 says some.
We
Last-
will pass an interim order.
Lords.
Because either, this will, otherwise the matter will become in flux, okay? Third, Sri S. Bhattakur, learned counsel for the petitioner.
Petitioner.
Who has put to challenge on a judgment dated 18/10/2025 passed by the learned Assam Board of Revenue in case number 87 RA within bracket K oblique 2023 full stop. It is contended that initially the petitioner had made an application under section 23 of the Assam, what is the name of the act? Tenancy Act 1971. What is the name of the act? Settlement.
Temporary
1971.
Assam Temporary Settled Areas Tenancy Act.
Tenancy Act 1971, which was decided in their favor, full stop. However, they said decision was subject matter of challenge where?
Which one, your lordship?
The initial order of giving you recognizing.
That was subject matter of challenge before the Board of Revenue.
And Board of Revenue
Board of Revenue, then your lordship, that was your lordship, Board of Revenue.
interfered. Okay.
Then we came before this honorable
Okay.
High Court.
They said, decision was challenged by the present private respondent, which was allowed by the learned board, full stop. The said decision was the subject matter of challenge by the present petitioner in WPC 588 of 2010. And an order was passed by this court on 19/11/2015, giving liberty to the petitioner to file afresh, full stop. On such application, comma, the status of the petitioner as Khatian has been maintained. Full stop. It is this order which is the subject matter of challenge in the present round of litigation before the Assam Board of Revenue. Full stop. Para. Let notice be issued. Returnable on 4th of February 2026. Revenue, madam, here amount of for one and one only, madam, one. And that's for two, three, four. And G does for all,
8 to 12.
all the respondents.
But respondent number 7, she has expired, Lordship. Respondent number 7.
What about 5? 5 and 6?
5 and 6, your lordship, they are owners, your lordship.
Owners.
And who are they?
They are the, your lordship,
Legal heirs.
legal heirs of the Amjad Ali, your lordship. Who is the
Owners means owners of who?
owners of the land, your lordship. That,
So you're disputing they're not against the owners. You're
no, your lordship, we are against them. your
Tenants.
lordship. So tenancy right was given to them, your lordship.
okay.
We have got.
Sri G does appearing and caveat except notice on behalf of respondent was 8 to 12. 8 to 12.
Yes, 8 to 12.
Who has also submitted that the respondent number 7 has already expired.
Lordship, the petitioner, they have, before the Board of Revenue, they have filed another appeal, 89 RAK, which is the 89 RAK, where they have mentioned about the respondent number 7. And in the argument stage, we have already said that the respondent number 7 has expired, but they still have made them part.
Okay.
We will,
Has expired, and this fact was known to the petitioner.
Yes.
Full stop, para. Be that as it may, let steps be taken for service of notice upon the other respondents by speed post with AD. Let the records be called for.
Yours.
Para. Sri Port Harcourt, the Learned Council prays for an interim order. Para, considering the facts and circumstances and in the and by balancing the equities, it is provided that the impugned judgment dated 18/9/2025 passed by the learned Assam Board of Revenue shall remain suspended till the returnable date.
Sure.
Records may be called for.
Go ahead.
Records
Already.
called for.
Unlisted as well. Yes, Asay.
My lord, this is similar, my lord.
This is similar?
Eviction matter.
Same matter we have passed.
Yes, my lord. In fact, 4 matters I've mentioned. I mentioned on 17th and permission were granted, but today 4 matters were left out. So I again mentioned, so they are sending from bench one by one. They have sent one only now.
Your matters have to be filed. We have a report from the bench. Those are all defective.
My defects clear.
Wakalatnama does not bear a signature.
My lord, I have called.
Affidavit does not bear a signature.
Yes, my lord.
Don't
That-
file it in this manner.
That we have cleared.
And you get it passed through the notary, you'll be in difficulty, madam.
My lord, the notary, my lord.
No, you'll be in difficulty. We are telling you. It's not that we do not know anything. We take stock of everything what is going on. You file a mention memo, on the strength of mention memo, matters get listed
My
and
lord-
it is lying defective.
My lord, the notary officer, he sits in the new building, my lord. And
So if
my-
the deponent's signature is not there,
deponent
it
was
can
not
there be a
allowed to enter.
justification?
He was not allowed to enter. So I have just taken him out and showed the petitioner that he is the petitioner.
And the petitioner will not sign thereafter.
My lord,
Madam, we are not on the aspect how the identification is done. We are on the aspect that the deponent has not even signed and he have presented it. He has not even signed the wakalatnama. What is your justification of the wakalatnama?
in fact, my lord,
Wakalatnama, what justification?
they were here, my lord, but
Oh, then don't sign wakalatnama, not required.
then, my lord, I have
Can this be an
called-
answer that
No.
they were here?
My lord, they came on Sunday and they have,
Not from
they
you,
have
madam.
stayed here, my lord. They are even,
You are a
today
citizen.
they are here, my lord. They will be, my lord, they are waiting for my
You are
lord.
a citizen council, madam. We are not required to say these words to you. That the wakalatnama is not required to be signed because they are here.
My lord.
What
they-
is this kind of an answer?
My lord, we filed 23 petitions, my lord, at a time, so.
We are not board of
we
concern. We are
hurry-
not in a concern with that. Those 26 or 206.
That is why, my lord.
We are not,
call-
we are not
we made a
concerned.
call yesterday, they said.
Every
we are-
case has to
we
be
are-
filed in accordance with law.
They came and, my lord, put their thumb impression
okay.
and they also signed yesterday.
Okay. So here, who will take notice? Same.
Same, my lord.
Anyone from the forest department? Same আছিল, forest.
From the PN Goswami, he said he'll send one junior, my lord.
চাই ল'বা একে হেৰি কৰিছে এটা একে হ'ব Okay. Mr. Goswami, which matter?
Lordship, I beg your pardon, Lordship, I came 14 and 15. I came 14 and 15. After long persistent cases come. So Lordship, take this matter on opening.
14, 15?
Date may fix, Lordship.
Or he'll give dates. Mr. Sheikh?
I have item number 13.
He'll give dates. He'll give dates after the vacation.
My lord, that madam had appeared, that my name may be recorded.
Okay, I say it. Huh? Vacation, okay. Okay.
Oh, listen.
Okay, wish you all a very happy vacation.
Happy
And a
Same
New
to you.
Year.